Good morning. Everybody hear me okay?
Good morning. Yes, Your Honor, we can hear you just fine.
Okay, awesome.
Morning, Your Honor.
Morning. Okay, I think we have almost do we have both? We've got one witness. I see. Are we waiting on one more? Good morning. Oh my goodness. Everybody hear me okay?
Good morning. Yes, Your Honor, we can hear you just fine.
Okay, awesome.
Morning, Your Honor.
Morning.
Did y'all say you're waiting on the other witness?
I believe we're waiting on Allison unless she's there with you.
This is Allison. We're using the same computer. We're instructed just to use the witness computer, so I'm here. I just wanted to make sure I wasn't holding you guys up because I'm here.
Perfect. Thank you. Okay, so we've got a couple of minutes. But I guess if we're all here, we can get started. Is that okay with everybody? Yeah?
Yes,
All
Your
right.
Yes, Your Honor.
Okay, so hold on, because I've got to time you guys. I want to make sure I do that correctly. All right, so if everyone's ready, we'll jump into pretrial.
Yes, Your Honor, the plaintiff is ready to proceed for pretrial motions.
Defense is ready as well, Your Honor.
Awesome. You may proceed.
Your Honor, by way of brief background, today's case is a premises liability negligence case. The evidence today will show that the defendant's premises, Chimes Department Store, created an unreasonable risk of harm, did nothing to fix that harm, and knew about the harm there on the premises. Now, we've had some discussions with opposing counsel, Ms. McGann. Ms. McGann, how do you pronounce your last name? I just want to make sure I'm getting that right.
McGuigan, Mr. Hobbs.
McGuigan. Okay. We had a conversation with Ms. McGuigan before trial, and we've actually had some stipulations that we've agreed on. Would Your Honor like me to read those out to the court now?
That would be great. Thank you.
Yes, Your Honor. We've stipulated to pre-admit exhibits 16 through 30. And we've also agreed to exclude exhibit 37, Your Honor. And that's the only pretrial issues the plaintiff has. And Your Honor, we're ready at this point to proceed to opening statements.
Okay, I'm sorry. Can you tell me again which one was excluded?
Yes, ma'am. That was exhibit 37.
37.
Yes, ma'am.
Okay. All right. With those stipulations, if there's, so no other pretrial matters.
Your Honor, we do have a couple other housekeeping matters as well as two substantive motions. Your Honor, my name is Carolyn McGuigan. I am here today on behalf of the defendant, Chimes Department Store. And in addition to the exhibits that Mr. Hobbs just discussed, we have also agreed to pre-admit exhibits 3, 6, 11, and 12.
And that's our understanding, Your Honor.
As well as to preclude exhibit 40.
Okay.
Additionally, Your Honor, we have two substantive motions to argue before the court.
Okay.
The first is that pursuant to Your Honor's pretrial order number 2, this is a bifurcated trial. It is to be tried on the issue of liability only. As such, Your Honor, we move to preclude exhibits 8 and 9. These are pictures of the plaintiff, Jordan Gilmore's knee after she had knee surgery. It shows her knee with a scar with multiple staples in it. Your Honor, we have offered to stipulate to the fact that Jordan Gilmore did injure her knee and had to have a knee replacement surgery. And based on that, we believe that these pictures 8 and 9 will serve to only confuse the jury as to the issues they have to determine here today, which are not damages. They are only liability, and therefore these pictures should be precluded under Rule 403.
Mr. Hobbs, response?
Yes, Your Honor. One of the things that we're required to prove today by a preponderance of the evidence is that there was a proximate cause of injury in today's case, which requires that we prove that there was an injury. These photos are not gory, they're not bloody, they're not, they're not crash photos or anything like that. It's a clean, sanitary photo of somebody's knee that shows the extent of the injuries. And we have to show today that the plaintiff was in fact injured, that Ms. Jordan was injured as a result of the actions taken by the defendant.
May I respond, Your Honor?
Yes, you may.
Your Honor, the stipulation that we have offered proves exactly that. There's no dispute here today that the plaintiff was in fact injured. So these pictures are not necessary to prove that. They will serve only to confuse the jury and to potentially inflame the passions of the jury if they see a serious injury that has not yet healed from a significant surgery. Furthermore, Your Honor, the causation that that plaintiff's counsel has to prove is that anything that my client Chimes Department Stores did led to this injury. There's no dispute that the plaintiff was injured as the result of a fall. The causation question is whether conditions that my client potentially had control over led to that fall.
I'm going to deny the motion.
Yes, Your Honor. Additionally, Your Honor, we move to preclude any evidence that after this accident, my client Chimes Department Store installed a light switch as a subsequent remedial measure under 407. By way of additional background, Your Honor, prior to this incident, there was a light outside in the area where the plaintiff fell. However, the only switch for that light was located in a different store over which my client had no control. After this incident, my client installed a light switch that allowed them to turn that light on and off. Your Honor, there is no factual dispute as to whether prior to the incident, my client in fact had control over that light. The evidence will show that they did not. And any issue as to whether they could have had control over that light is a question of feasibility, which we contend will not be in dispute today. If asked, the defendant's party representative, Ms. Geller, will say that they could have installed one of those switches. So therefore, because there will be no dispute as to control or feasibility, this is a subsequent remedial measure that should be precluded under 407.
Response, Mr. Hobbs?
Yes, Your Honor. Under Rule 407, there are several different exceptions that apply in the situation. Your Honor, we would not be offering that evidence today to show culpable conduct or any sort of negligence on behalf of the defendant in today's case. We would, however, contest that they were in control of this light, that they did have ownership over this light, and the jury verdict form that the defense counsel has indicated to us they were using puts a third party and Ms. Jordan herself as culpable in this situation. And because of that, they've put at issue ownership, control, and the feasibility of the precautionary method that was taken. And again, Your Honor, we wouldn't be using that evidence to show that this was a negligent action and that there was some kind of culpable conduct here. It would just be to show that they had ownership over it, they had control over it, and that it was feasible before my client was injured that this light switch be moved into the defendant's own department store.
Your Honor, this cannot be used to prove ownership. Chimes Realty was leasing the property from Kermit Realty LLC, who is the owner of the property. That is not in dispute today, so nothing, much less the subsequent remedial measure, can be used to prove that. Furthermore, Your Honor, as to control, the plaintiff's counsel is essentially agreeing with me here, right? Prior to this incident, my client did not control this light because the facts will show that the switch for this light was in a different store that was leased and run by a completely different business. The fact that they later installed the switch is a question of feasibility, whether or not they could have installed that switch prior. And if they had installed that switch prior, then they would have had control. But the facts show that absent that switch, there is no control. So unless feasibility is disputed, which we argue it will not be, this is not admissible as it is a subsequent remedial measure.
I'm going to grant the motion.
Your Honor, I would simply ask the court if we could get a limiting instruction as to the effect of, and Your Honor, I'll consult with you if we decide to go into sort of that evidence beforehand based upon your ruling. But at that time, I would like to discuss with Your Honor a limiting instruction that if that evidence is offered with Your Honor's permission, that it would only be offered for the purposes of showing ownership, control, or feasibility.
We can discuss if that comes up.
Yes, Your Honor.
Any other pretrial?
I'm sorry, Your Honor. I think I'm just a little bit confused. So the motion is granted, but there's a potential to renew it should any of those issues become disputed?
I think Mr. Hobbs is asking that if we get into a line of questioning that perhaps crosses over the line that we've just set, that I would consider a limiting instruction if necessary, to tell the jury that the evidence is solely towards or goes towards feasibility. I'm getting into arguments that you all would be making. So I think, Mr. Hobbs, if I have restated that correctly, that was my understanding of your request.
Yes, ma'am, that's correct. Yes, Your Honor.
Does that help? I'm going to ask you, could you say your last name one more time? I'm so sorry.
That's all right. It's McWiggin, Your Honor.
McWiggin. Okay. Thank you.
Your Honor, with that, we are ready to proceed to opening statements.
Okay. All right. You guys give me 30 seconds. I want to I want to fix my timer really quick, and then we will jump in. Okay, sorry about that, but I think I got it ready. So with that, we'll move into our opening statements. Of course, we'll start with plaintiff.
May it please the court. Your Honor, opposing counsel, members of the jury. Dark, derailed, dangerous. In January of 2019, Jordan Gilmore was injured in the defendant's department store because of a dark stairwell, a derailed landing, and a dangerous condition. But our story doesn't begin in January of 2019. Our story begins over a decade ago in 2005. In January of 2005, the defendant had just moved to their new location. And they noticed that in the back of their business, there was a railed landing and a staircase. And they sent an email at that time to their landlord. We need this railing removed ASAP. And it was done immediately. The landing and stairs had been derailed, and the stage was set. Skip forward 5 years. We're now in January of 2010. And one of the defendant's employees is walking out to take some trash to the dumpster, doing something the defendant told him to do. And as he's walking down those dark steps, he falls flat on his face on the concrete. Well, what could have prevented that from happening? Well, in the defendant's own words, shouldn't have gone out there at night. We should fix that light. Now we move to 2018. And an OSHA inspector comes to the defendant's business, takes a look around the premises, and walks out onto the elevated platform. Hey, what's up with that light up there? It's automatic. And now we're at 2019 on that cold, windy, and dark night. And Jordan Gilmore, the plaintiff, is out where the defendant told her to be. And as she walks up those dark stairs to that derailed platform, she falls, injures her knee, has to have a knee replacement surgery. Members of the jury, it is that dark, derailed, and dangerous platform that is the reason you are all here today. Now, as the plaintiff in today's case, we carry the burden of proof. We have to prove to you by a preponderance of the evidence, that is, that it's more likely than not, that it was the defendant's actions or inactions that led to Miss Jordan Gilmore's injuries. And to do that, we're going to call a couple of witnesses today because we're not afraid of that burden. In fact, we embrace it. First person you're going to get to hear from today is Miss Jordan Gilmore herself. Miss Gilmore, could you turn on your camera for a moment? Members of the jury, this is Miss Gilmore, a proud Texan, active in her church, and heck, she even plays cards on the weekend with her friends. Miss Gilmore, you can turn off your camera. When Miss Gilmore takes the stand, she will tell you how dark that stairwell was, how there was not a railing on the stairwell or that elevated platform. And she will tell you it's because of that dark and derailed platform that she fell. And after Ms. Gilmore is done explaining that to you, members of the jury, we're going to call by deposition an expert witness before you today, Kelly Danes, an expert who has experience working in code, working in making sure that businesses and buildings adhere to the laws that we have adopted here in the city of Waco to protect our employees and the public. And she will tell you that when she conducted her own inspection of the defendant's premises, that those premises did not meet the requirements of those codes that are meant to protect you and the employees of the defendant's business. And after we're done proving to you today that the defendant is liable, I anticipate that you're going to hear some evidence from the defense. They're going to try to distract you with a lease. They're going to try to convince you that it was the actions of Miss Jordan herself that caused her injuries. I anticipate they're going to call the owner of Chimes Department Store before you today, Reese Geller. And when Miss Geller takes the stand, I anticipate that she's going to have to tell you some things that She may not want to. She's going to have to tell you how her business kept their dumpsters out there, how her employees took their trash out there, how her employees smoked there, and how there was no railing or light in that dangerous platform. And after the defendant has to admit those things to you, I anticipate you might hear from an OSHA representative. But what that OSHA representative will have to tell you today is that when he inspected the premises and did not issue a citation, it was based on false information that was given to him by the defendant's own managers. So when you have an opportunity to look at that report today, you'll know it's not even worth the paper it was written on. And at the end of today's case, when the judge instructs you and charges you as the members of the jury, you're going to be confronted with a jury verdict form. And that jury verdict form is going to have 3 different names on it. It's going to have Chimes Department Store. It's going to have the realty group that owns the property that the defendant was renting. And it's going to have Jordan Gilmore's name on it. And by the time that we're done looking through the evidence and the judge has charged you in today's case, I am confident that you will be able to answer yes, that Chimes Department Store was liable and that no one else was responsible for the actions that they took. Thank you.
Thank you, Mr. Hobbs.
Your Honor, may I just have a brief moment to set up before I begin?
You may.
Thank you. May I proceed, Your Honor?
You may begin.
Jordan Gilmore had a horrible accident. You're not going to hear us say any different today. Now, we understand wanting to hold somebody responsible, but here today, members of the jury, the plaintiff will try to pin responsibility on the wrong people. Because Chimes Department Store did not control the loading dock where the plaintiff fell. And they didn't control the plaintiff's choices. Without control, there is no responsibility and there can be no liability. Today, you will learn that it was the landlord who controlled that loading dock, and it was the plaintiff's choices that actually caused her injuries. Chimes Department Stores had nothing to do with it. Now, before we go any further, I want to take a moment to tell you a bit about Chimes Department Stores. Chimes is a small town department store located right here in downtown Waco. They're a family-run business. They were started 2 generations ago by a husband and wife. And today, that husband and wife's granddaughter, Reese Geller, still owns and runs the store. You're going to hear from Reese Geller today, and she's going to explain to you that Chimes leases their storefront from a company called Kermit Realty LLC. And under the terms of that lease, the space that Chimes leases, the space that they are responsible for, well, it ends with the back wall of that store. Anything beyond that wall, which includes the loading dock that the plaintiff fell off of, is the responsibility of the landlord, not of Chimes Department Store. Now, the plaintiff won't be able to prove anything to the contrary. Instead, they're going to call Kelly Danes, a paid mechanical engineer who plaintiff's counsel just claimed is an inspector, but in fact, you will learn they are paying her for her opinions. But payment or not, Kelly Danes will not be able to tell you anything about the first thing that the plaintiff has to prove, whether or not Chimes controlled that space. And if they can't prove control, then their case ends right then and there. But then Kelly Danes won't be able to tell you that there was actually anything unreasonably dangerous about the space where the plaintiff fell. She's going to tell you about OSHA and IBC regulations. And you'll learn that those are regulations that companies have to follow to keep their employees safe at work. But when she does that, ask her to tell you that those regulations apply to loading docks. You will learn that they don't. And that means they don't apply in this case. Now, we, on the other hand, are going to bring you Perry Hayden, an actual OSHA investigator, unlike Kelly Danes, whose entire job it is to inspect workplaces and determine whether or not they are up to code with federal workplace safety regulations. You're going to hear that Perry Danes investigated the Chimes department store in 2018 and did not issue a single citation. He saw everything that the plaintiff claims is wrong with this area. He saw there were no railings. He saw everything that led to the plaintiff falling, and he did not determine that there was anything that warranted a citation. Members of the jury, therefore, even if the plaintiff can establish that Chimes controlled that area, which they will not be able to do today, they will not be able to establish any violations, and so they will not be able to establish any liability. No control, no responsibility, no liability. And then there's one more thing you're going to have to consider today. The unfortunate truth that the plaintiff's own choices are what actually caused her injuries. Now, we are not saying that Jordan Gilmore is a bad person or that she acted egregiously. She just made a mistake. It was dark, it was cold, and she went out back to smoke down a set of stairs you'll learn she'd used thousands of times before. When she came back up those stairs, rather than ask her coworker Riley, who'd come out to smoke with her, to open the door all the way so she had more space, rather than ask Riley to move out of the way, rather than close that door so she could go up and around onto the platform, the plaintiff chose to scoot around that half-open door and step right to the edge of a platform that she knew had no railing. Unfortunately, you'll learn she slipped and she fell. But members of the jury, that is the result of her own inability to use ordinary prudence. Chimes department stores had nothing to do with that. At the end of this trial, when I come before you again, you will have learned three things. First, the landlord, not Chimes department store, was responsible for that loading dock. Second, none of the regulations that you will hear about today applied to that loading dock. And third, it was the plaintiff's own choices that actually caused her injuries. The landlord controlled that loading dock, and the plaintiff controlled her choices. Chimes department stores had nothing to do with it. No control, no responsibility, no liability. As such, at the end of this trial, I am confident that you will be able to return the only verdict that the evidence supports and that justice allows. A verdict finding Chimes department stores not liable. Thank you.
Thank you, counsel. All right, there we go. Okay, Mr. Hobbs, you are on to presenting your first witness.
Yes, Your Honor. The plaintiff calls Ms. Jordan Gilmore to the stand at this time.
Oh, there we go. You may proceed when ready.
Yes, Your Honor. Good morning, Ms. Gilmore. Could you please introduce yourself to the members of our jury?
Hello there. My name is Jordan Gilmore,
And where do you live, Miss Gilmore?
Waco, Texas.
Are you currently employed here in Waco?
Unfortunately, no, I'm not.
Were you working at the time you were injured?
I was working at the Chimes department store, but not anymore.
And how long had you been working at Chimes?
10 years.
And why aren't you working there anymore?
Well, I suffered an injury on the job. I, was wanting to recover, and it looks like when I did, they no longer had a spot for me. So more or less, I got fired.
Objection to the testimony that the plaintiff was fired, Your Honor. 403, as this is a bifurcated trial.
Okay. Mr. Hobbs?
Yes, Your Honor. The fact that the witness is fired doesn't in any way inflame the passions of the jury, or it makes it more likely that she was injured today because she was fired, Your Honor. This testimony we just heard, it goes directly to the injury that was suffered, which is, again, something we have to prove today, Your Honor. We have to prove proximate cause.
Ms. McWiggin?
Yes, Your Honor. The plaintiff's employment status is a result of the injury. That is the very definition of damages, which the jury is not here to consider today. As such, this will confuse them as to the questions they are here to answer. It goes directly to damages and should be precluded under 403.
I'm going to overrule the objection, but Mr. Hobbs, let's be careful with further questioning.
Yes, Your Honor. Now, I want to talk about that accident, but first, I wanted to ask you something. Did you used to smoke?
Yes, a pack a day.
And when you smoked, where at the building were you told to do your smoking?
Out in the back. We were specifically told to do that because if we did it in the front, the customers would see. So if we wanted to smoke, we took a break, we did it in the back.
And who told you to do that?
My employer, that would be the management at Chimes.
Do you have an exhibit book in front of you?
I do.
Can you turn to the exhibit number 1 for me, please?
Yes, sir.
What is this exhibit?
That looks to be a memorandum. It's from the management to the employees at Chimes.
Does it appear to have been changed or altered in any way since the last time you saw it?
No, sir.
At this time, Your Honor, plaintiff moves to admit exhibit 1 into evidence.
Ms. McWiggin, any objections?
No objection, Your Honor.
Exhibit 1 is admitted.
Permission to publish to the jury, Your Honor.
Yes.
Ms. Combs, if we could get that up. Now, Ms. Gilmore, can you read the last 2 sentences of the first paragraph, starting with "as"?
Pardon. As you have been told before, if you're going to smoke, you need to smoke out behind the store where our dumpster is. That is the only place you should take smoke breaks on the premises.
Did you listen to your employer when they sent you that memo?
Oh, yes, always.
Did you ever smoke out in front of the building?
Never.
Ms. Gilmore, I understand what we're about to go into might be difficult. So if you need any time, if you need to take a break, just let me know. But we need to go through what happened to you on January 23rd, 2019. Do you remember that day?
Yeah, of course. 2 days short of a month after Christmas. Yeah, I do.
And where were you that day?
I was working the 12 p.m. to 8 p.m. shift at Chimes as a cashier.
And where were you at whenever you were injured?
I was at the back of the building where that landing is, taking my smoke break.
What was it like outside on January 24th?
It was dark. At that time of the year, it gets dark pretty early on in the day, 7 p.m. And it was cold and windy.
Was there any lighting out there on that elevated platform?
No, sir.
Was there a switch to turn on any lighting out there?
There was a switch, but we couldn't do anything because it was in the building of a neighboring shop. It wasn't actually inside Chimes.
Did any other employees or you yourself complain to management about that light switch?
Oh, yes, we did.
Did they ever tell you anything about what they could or couldn't do with it?
I mean, they didn't really do anything about it. I mean, they acknowledged that it was there. It's just, it wasn't inside Chimes, it was in that other shop.
So I want to move and discuss what happened that resulted in your injury. You already told us that you were out taking a smoke break. Where were you at whenever you were taking that smoke break, specifically in the back of the store?
I was out by the dumpsters where we have to take out the trash throughout the day.
Did you have to walk down any steps to get to that location?
Yes, there is a set of stairs.
So after you finished smoking your cigarette, can you tell us what happened?
Yes, so, I mean, pardon if my memory is a bit foggy, but I do remember my coworker, Riley Huntsberger. She was there, and I mean, I wasn't out there too long. I mean, 5 to 6 minutes. I mean, it was cold and windy, dark. I mean, why would I lollygag out there, you know? So I went and I, went up the stairs. And the way it's set up, the stairs by that landing, there's no railing. So I had to support myself with the wall on one side. So as I was walking up, I had to do that. And then she was holding the door open, and it was windy. So, I mean, she was holding it because she didn't want it to like blow or get out of control or out of her control. And then there was light, I couldn't see, but like it was blocked, so I had to get around it. And that's what I was trying to do, to get around it near that unrailed part of that area. So I walk up, and then there's that issue with Riley holding the door like that. And, then I go down, and it's like, before you know it, I know I'm going to fall, and I know I'm going to fall to the ground. So what I do is I jump, and the way I fell, it was just, fell with most of my weight on my right leg. So Riley helped me back. I clearly remember saying, "This isn't good." And then we finally got back inside the department store.
And after you got back inside the department store, did you tell the manager on duty about what happened?
Yes, I went and told the manager. My shift was, going to end at 8. She was there. I approached Miss Lane Kim and told her what happened to me.
And did Miss Kim tell you anything in response?
Yes, yeah. Elaine Kim told me, yeah, we probably should have fixed those stairs a long time ago. I talked to the owners about it a few times, but we always have bigger problems to fix, I guess. Sorry about that. That's what she said.
Now, we've already talked today about the fact that you used to be a smoker. Do you still smoke today?
Oh, no. That day and what happened to me, I took that as a sign from God that I don't need to be smoking anymore. So the answer is no.
Now, you said you had to have surgery on your knee. Was there any scarring as a result of that?
Yes, yeah. I mean, I had to have 28 staples. You know, I have scars that come when you have a knee replacement. So they're still here to this day. I look at them every day.
Would you recognize a picture of your knee as it was shortly after the incident in your surgery?
Yes, sir.
Could you flip to exhibits 8 and 9 whenever you get a chance?
I have them in front of me.
Are these the pictures of your knee?
Yes, sir.
Do they appear to have been changed or altered in any way since the last time you saw them?
No.
Your Honor, at this time, plaintiff moves to admit exhibits 8 and 9 into evidence.
I know we've discussed these previously, so if there's no separate objection, Ms. McGuigan, then I will admit those 2 photographs.
No additional objections besides what we discussed in motions, Your Honor.
Thank you.
Ms. Combs, if we could get exhibit 9 put up. 8 and 9, perfect. Ms. Gilmore, are you still in pain?
Yes, every day. Excruciating.
No further questions at this time, Your Honor.
Cross?
Yes, Your Honor. Good morning, Ms. Gilmore.
Good morning, ma'am.
I'm going to ask you a few more questions about what happened on January 23rd, 2019, okay?
Sure.
I want to start by talking a bit more about the area where you fell. You fell outside the back exit of Chimes department store, right?
That's correct, ma'am.
That's where the loading dock is.
The landing, yeah.
Well, you yourself would agree that that is in fact a loading dock.
Yeah, I mean, someone call it that. Yeah, I've always seen it as a landing or a platform.
But you have called it a loading dock.
I may have, yes.
Okay, Ms. Gilmore. In fact, the loading dock is what you fell off of, right?
Yes. Yeah.
And loading docks, there where businesses receive shipments.
Yes, that's what they're ordinarily used for.
That is what they're used for.
Yeah, that is, pardon.
And loading docks, they don't have railings.
No.
You'd agree you can't put a railing on a loading dock.
I don't know if you absolutely can't, but to my knowledge, they don't come with railings, ma'am.
In your words, Ms. Gilmore, you can't put a railing on a loading dock, right?
I do remember saying that, ma'am. So yes.
Now, you went out to that loading dock often, right?
I did. I mean, that was in the area where we could take our smoke breaks in the back of Chime. So yeah.
It's also the area where you went to throw out trash, right?
Yes, yeah, there are dumpsters back there.
And you would do that once or twice a day.
Yes,
And those smoke breaks that you just talked about, you would take one of those about once a day.
yes,
Between the garbage and the smoking, you'd go out to that loading dock about 20 times a week.
yes,
It's fair to say you're pretty familiar with that loading dock.
yes,
That includes the stairs.
yes, ma'am.
It includes the lighting.
Yes.
It includes the doors.
But yes, yes, ma'am.
Now, I want to talk more about January 23rd, 2019 specifically. Towards the end of your shift that night, you went out to the loading dock to smoke, right?
Correct. I took a smoke break.
It's true that sometimes you smoke in your car while you're at work.
Yeah, I smoke in my car on the way to lunch. Mhm.
But that evening, you didn't go smoke in your car.
No, ma'am.
And when you went out to the loading dock, it was around 7 p.m.
Yes,
At that point, the sun had set.
yes,
It was dark.
correct.
In fact, it was pitch black.
Yes,
Now, you knew the light in that area was controlled by the store next door.
yes,
You knew there was no other light outside.
no,
The only light was coming from inside the store.
yes, that's correct.
Now, your coworker, Riley, she also went out to smoke with you, right?
Yes, she did.
She stood in that doorway.
Correct,
She propped the door open,
correct.
but you went down the stairs.
I did.
You smoked a cigarette,
I did.
and then you came back up the stairs.
I did.
You were outside for a total of about 6 minutes, right?
Yeah, more or less, yes.
You wanted to get back inside as quickly as possible.
Yes, it was cold.
That's right, it was cold, right?
Yes.
Now, I want to move to after you finished that cigarette. When you were done, you came back up the stairs.
Yes.
At that point, that door was still propped open.
Right.
Ms. Gilmore, I'm showing you what's already in evidence as Exhibit 3. That door, it was propped open like this, right?
Correct.
And you were coming up the stairs on the other side of this door.
Right.
You could see that the door was blocking most of the landing.
Yes. Yes.
You could see there was only a small space to get around the door.
Yes.
And you're aware this door opens further than we see in this picture.
Right. But I mean, that's a photo that was taken in the daylight. This happened in the evening. So, I mean, it doesn't look the same.
Ms. Gilmore, I'm just asking you whether you're aware that this door that we see here opens further than it's opened in this picture. And you are aware of that, right?
Yeah, yes, it does.
You're aware that this door opens all the way.
It does.
Now, Ms. Gilmore, I'm showing you what's already in evidence as Exhibit 6. This is what that door looks like when it's open all the way.
Right.
There's a lot more space on that platform for someone to come up the stairs.
Yes.
When you were coming up those stairs on January 23rd, you didn't ask Riley to open that door all the way.
I don't recall, ma'am.
Ms. Gilmore, you don't recall whether you asked Riley to open the door all the way?
No, ma'am. Ma'am, I apologize. I don't.
Well, you can't tell us that you did ask Riley to open that door all the way.
Correct. I can't.
And you also didn't ask Riley to move out of the doorway so you could have more space.
No, I don't remember saying that.
You can't tell us that you did ask her to say that.
I can't.
And Ms. Gilmore, you didn't ask Riley to close that door all the way, right?
I didn't.
Instead, you tried to step around that half open door, right?
Right. That's what I did.
Without asking Riley to open or close it all the way.
Right.
Objection, Your Honor, asked and answered.
Overruled.
And when you stepped around that half open door, that's when you fell.
Right.
No further questions at this time, Your Honor.
Brief redirect, Your Honor, whenever the court is ready.
Okay. Yes. You may proceed.
Ms. Gilmore, did you ever sign a lease with Kermit Realty Group?
Objection outside the scope of cross.
Your Honor, pursuant to the rules in this jurisdiction, there is no scope as to redirect examination, Your Honor.
Overruled.
Back to my question, Ms. Gilmore. Did you ever sign a lease with Kermit Realty?
No, sir.
No further questions, Your Honor.
Okay. Mr. Hobbs, we will let that witness go. Mr. Hobbs, you can proceed.
Yes, Your Honor. At this time, we would call Kelly Danes by deposition. And Your Honor, just a point of order that I want to bring up with you. We are going to be bringing up pieces of evidence as though we would during an actual direct examination. I just wanted to make sure the court was aware of that. Those documents will be identified throughout, and everything that we're going to be talking about has been pre-admitted per stipulations at the beginning of today's trial.
Sounds good.
So with the assistance of Ms. Combs, we will read in parts of this deposition starting on page 2, line 6. Can you please state your name for the record?
My name is Kelly Danes.
Moving down to line 12, tell us about your education.
I have a bachelor's of science in mechanical engineering from the University of Wisconsin-Madison.
Now to line 24 on that same page. I noticed your CV lists you as PE. What is that?
It stands for professional engineer.
Now on to line 2 of page 3. What do you have to do to become a professional engineer?
Well, you have to graduate from an accredited engineering program, which I did. Then you have to pass the fundamentals of an engineering exam, which I did. Then you work as an engineer for 4 years before you take the professional engineering exam. So I took that as well and I passed.
Moving down now to line 13. What do you do professionally?
I'm the president of Danes Engineering LLC.
And what does your company do?
We provide forensic and investigative engineering consulting and litigation support, specializing in industrial, commercial, and construction engineering, operations, safety, patents, and regulations.
Moving now to page 4, line 7. How long have you been in the business as Danes Engineering LLC?
I've been doing that for the past 10 years.
Now down to line 14. How many incidents have you investigated?
Over 60.
And now down to line 19. How many times have you testified at trial?
Twice prior to this.
At this time, Your Honor, plaintiff offers the testimony of Kelly Dibbs as an expert in investigative engineering, consulting, and litigation support, specializing in industrial, commercial, and construction engineering operations, safeties, patents, and regulations.
Okay. Any objection?
Your Honor, we don't object to Kelly Danes being tendered as an engineer. However, we do object to her specialization in regulations. As we intend to elicit in our constructive cross-examination, Kelly Danes has only ever worked in private practice. She's never been a code enforcement officer. She's never worked for OSHA. Therefore, she does not have the requisite training and background to be tendered under 702 with a specialization in those regulations.
Brief response. Yes, Your Honor. We just elicited testimony via this deposition that she specializes in industrial, commercial, and construction engineering, operations, safety, patents, and regulations, and that she's testified as an expert before at least 2 times and has investigated over 60 different incidents. She has the experience and the qualifications necessary to speak as an expert on regulations in this area.
I'll overrule the objection.
Yes, Your Honor.
Moving now to page 5, line 15. What did you review in coming to your opinion in this case?
I reviewed the deposition of Jordan Gilmore, the deposition of Reese Geller, a number of different regulations from the Occupational Safety and Health Administration, a number of provisions from the International Building Code, and I conducted an inspection of the location of the fall and took pictures of that area.
Moving now to page 6, line 18. What do those pictures show?
Well, as you can see, there are no railings on the steps up to that landing area, and there's no railing on the landing area itself. Plus, you can see where the railing used to go into the concrete and how the concrete around those areas is worn down and cracked. So you can see that this is a pretty dangerous situation.
Moving now to page 8, line 16. Okay, what opinions have you come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and landing in question, and the facilities in question must be in compliance with those codes and regulations.
What is the basis for that opinion?
Well, in regards to the International Building Code, the city of Waco adopted that code and incorporated it into its own city ordinances on March 20th, 2001. The OSHA regulations were enacted into law in 1970.
Moving now to page 9, line 14. Why are those significant in this case?
There are general provisions that require an employer and or the party responsible for maintaining a building or structure to keep that building or structure in a safe and well-maintained condition free from the recognized hazards. The stairs, the broken off concrete, the lack of stair railings, the lack of railings on the platform, the lack of a light switch to turn on the light above those stairs were all hazards that
Objection, Your Honor, as to lines 23 to line 2 on the following page, lack of foundation.
Your Honor, this witness has testified via deposition that they conducted an inspection of the space. And as part of that inspection, they looked at the railing, they looked at the concrete, they looked at the lights. All of that's been testified to already, Your Honor.
May I respond, Your Honor?
Yes, please.
The lines that I'm objecting to, the ones that the witness is about to read, are an opinion that Chimes Department Store should have had a safety plan in place to identify those. There's no basis for that opinion.
Your Honor, this witness is an expert in the regulations that are required by OSHA and the International Building Code. As an expert in those areas, she would know what businesses are required to have in order to protect their workers and the public at large.
Your Honor, unless Ms. Daines can point to a part of the regulations that say that Chimes Department Store was required to have one of these plans in place, then there's no basis for that opinion.
Your Honor, I rest on my prior arguments.
I am going to sustain the objection.
And just so we're clear, Your Honor, that's to, and Ms. McWiggin, can you just tell me which lines we're objecting to here?
To the lines that were about to be read, 23 to hazards on line 2, page 10.
Okay, perfect. Ms. Combs, could you start with line 2 on page 10 with the question or the answer that starts with so?
So fairly clearly, the defendant violated these requirements under both the IBC and the OSHA regulations.
Moving now to page 11, line 6. What other portions of the IBC codes and OSHA regulations did you find important in this case?
Well, 1910-37B requires that lighting must be adequate and appropriate for a building exit like this one. And 10.06.1 requires that any means of egress must be illuminated at all times the building is being occupied. In this case, there was a light above those stairs, but there was no switch for that light inside the Chimes store. So there was no way for employees to turn that light on when they went outside at night. A switch like that should have been installed long before this incident to make sure that employees could see where they were stepping.
Moving now to line 24 on that same page. What's next?
Next, we move to OSHA 1910-23D1 and 1910-24H and IBC 1009-11.
Why are those significant?
All of these provisions require that stairways or flights of stairs must have guardrails or railings on any exposed sides. Here, there was no guardrail on these stairs on the exposed side, which is obviously dangerous.
Do you know if there was ever a guardrail on those stairs?
Yes, there was, and it was removed at some point.
Moving now to page 13, line 16. All right, anything else?
1910-24H requires railings on all stair platforms, and 10.12.1 requires guardrails on all landings that are located more than 30 inches above the ground.
Objection. Your Honor, I'm sorry, as we started in the beginning of the line, I wasn't sure where we were, but Rule 106, the rule of completeness, requires here that we read in the entirety of IBC 10.12.1, as Kelly Daines is about to testify that it requires guardrails on platforms. However, as an offer of proof, IBC 10.12.1 specifically exempts loading docks from those requirements.
Your Honor, in responding to the 104 objection, the rule of completeness only applies to the deposition testimony, and we're reading in all of the segments, and opposing counsel will have an opportunity, if they should choose to in a few moments, to come up and read those regulations themselves. This witness is not here today. They can't testify live before us, and because of that, Your Honor, and any of those sorts of issues should be reserved for the defendant to bring up whenever they cross-examine this witness, which they will have an opportunity to do.
Objections overruled.
So moving down to line 22, page 13, can you start with the answer that says so, the line there?
So this landing would be subject to both standards. And depending on exactly where the plaintiff fell, if the stair handrails didn't provide enough protection, then a guardrail around the landing would give her something to grab onto to keep from falling.
Do either 1910.24 or 1012.1 apply to loading docks?
They don't mention loading docks specifically, but this wasn't a loading dock.
Well, why do you say that?
Just look at how it was used. Employees used this area to throw trash in the dumpster and used it to take smoke breaks. So this wasn't just a loading dock.
Moving now to page 15, line 7. Any final thoughts?
Honestly, I just don't know what the defendant was doing here. If the defendant had taken these simple steps, putting a guardrail along those stairs, putting a guardrail around that landing, making sure it was well lit, patching the concrete, then the plaintiff's fall would not have happened.
Your Honor, no further questions at this time.
McGuigan?
Yes, Your Honor. Before we begin our readings, we'd like to offer IBC section 1012.1 into evidence and show it to the jury.
Objections?
No objections to that, Your Honor.
You may proceed.
Yes, Your Honor. IBC section 1012.1 exception. Guards are not required for the following locations. Number 1, on the loading side of loading docks or piers. Turning now to the deposition of Kelly Danes. I apologize, Your Honor, I'm having a brief technical difficulty. Beginning on page 4, line 11. Have you ever worked in code enforcement at any level of the government?
No, I've always been in private practice.
Moving now to page 9, line 4. Do you know or have any opinion on who was responsible for the maintenance and repair of these steps behind the Chimes store?
No, that's not what I was asked to do. I assume it was Chimes, but that's just a guess. My job was to look at the steps themselves and see if they met code.
Moving now to page 10, line 4. Let me ask you this. If Chimes wasn't responsible for maintaining that area where the stairs were located in the back of the store, would the IBC apply to Chimes in regard to that area?
No, it wouldn't. The IBC applies to whoever has the responsibility to maintain that area.
Moving now to page 14, line 12. You would agree that this area was used by Chimes as a loading dock at times.
Yes, at times.
And a guardrail around that loading dock would certainly inhibit Chimes' ability to use it as a loading dock.
Yes, it would make it difficult.
Can you point to any specific regulations or codes related to how or if employers or others must place guardrails around loading docks?
No, I'm not aware of anything like that.
Your Honor, this concludes our read-ins for Ms. Kelly Danes.
You.
Briefly, Your Honor, before we conclude our case in chief, we would like to admit to the jury 1910.37 of OSHA regulations, 1006.1 of the International Building Code, 1910.24 of OSHA regulations, and 1021.1 of the International Building Code.
Any objections to those admissions?
No objections, Your Honor.
Okay.
And with that, Your Honor, the plaintiff concludes our case in chief.
All right. Ms. McGuigan, we'll move forward with your first witness.
Your Honor, before we move forward, the defense does have a mid-trial motion.
Okay.
Your Honor, the defense moves pursuant to Federal Rule of Civil Procedure 50A for a directed verdict. The plaintiff has failed to make a prima facie showing upon which a reasonable juror could find that Chimes department store had a duty here, much less that they violated it. We have not heard any evidence to show that Chimes department store was in control of the loading dock off of which the plaintiff fell. We have heard We have heard that the OSHA regulations that Kelly Danes just discussed do not apply to loading docks. Therefore, Your Honor, if the plaintiff has not proven control, has not made a prima facie showing of control, there is no way that they can establish that there was a duty and that any duty was breached. Therefore, Your Honor, here at mid-trial, a motion as a matter of law should be granted for the defense.
Mr. Hobbs, response?
Yes, Your Honor. The court must view any evidence brought in today in a light most favorable to the non-moving party, that being the plaintiff in this situation. Your Honor, we've put on evidence today to show that the defendant's own managers considered that back area of the property their own premises. There was a memo put in before Your Honor and the jury, Exhibit 1, that shows that the plaintiff was told that if he was going to smoke on the premises, that he had to do it out by the dumpsters. Your Honor, that goes to show actual control over this area, as the defendant was telling their employees who they have control over to go onto this dangerous, derailed, and dark platform in order to have their smoke breaks, take out garbage, and to load and unload trucks. Your Honor, we've met the burden that we've had to prove today in the light most favorable non-moving party, and at this point by a preponderance of the evidence, and therefore this motion should be denied.
May I respond, Your Honor?
You may briefly.
The plaintiff would have us believe that use alone equals control, but Your Honor, that is not sufficient. All they have shown is that they direct their employees to take smoke breaks out there, and that that's how they access where they use their trash. That is not sufficient to show control. Furthermore, Your Honor, the plaintiff herself said that she did sometimes take smoke breaks in her car. So the fact that she was out there was not specifically at the direction excluding everywhere else by my client. It was because she chose to go out there that night. Your Honor, the simple circumstantial fact that they used this space absent something more is not sufficient to show control that imposes responsibility.
Ms. McGuigan, I think you've set forth a good motion, but I'd hate to deny you the joy of putting on your case. So I'm going to deny that, and we'll move forward with your first witness.
Yes, Your Honor. At this point, Your Honor, the defense calls Reese Geller to the stand. Ms. Geller, are you with us?
Yes, sorry, I was muted.
That's okay. Good morning. Can you please introduce yourself to the jury?
Yes, good morning. My name is Reese Geller.
And Ms. Geller, what do you do for a living? Oh, Ms. Geller, you're muted again.
I'm the owner of Chimes here in Waco.
And what is Chimes?
It's just a local department store. It's comparable to Macy's, just on a small scale. We kind of sell a little bit of everything.
And what kind of business is Chimes? Is it a large corporation?
No, we're just a small family-owned store.
You say family-owned. Is that your family?
Yes, I worked there growing up with my grandparents. I took over from my parents. It's always been in our family.
And how long have you worked for Chimes?
My whole career. I worked my way up to owner. I started out just, helping my family when they owned it.
Where's the store located?
On Bosque Boulevard, downtown in Waco.
Now, I want to talk a bit more about that store location. Are you leasing that space on Bosque Avenue?
Yes.
Are you familiar with the lease for that location?
Yes, I'm familiar with the lease.
Ms. Geller, I'm showing you what's already in evidence as Exhibit 11. Is this that lease?
Yes, it is.
Who's the landlord on this lease?
Kermit Realty Group, LLC.
And who's the tenant?
That would be Chimes Department Store Incorporated, my store.
So going now to Section 110, what is the demised premises?
Essentially, this is the space that we lease from Kermit. Do I need to read it?
Yes, Ms. Geller, if you wouldn't mind
Okay.
reading 110.
It's approximately 18,000 square feet of space in the shopping center, and being the space crosshatched on the site plan, which shall have a minimum of 100 feet of clear interior width.
Now, that references a site plan. So I'm showing you Exhibit 12, which is also already in evidence. Is this that site plan?
Yes, it is.
Now I'm outlining an area in blue. Does this blue outline enclose the crosshatched area?
Yes.
So is that the demised premises defined in section 110?
Yes, it is.
Now the landing and stairs at issue here today, are they included in this blue area?
No, they are not.
Where are they?
They're on the back side of this, where this red X is.
Thank you, Ms. Geller. Your Honor, I move to preserve this as demonstrative exhibit 12A to be used on closing arguments.
Admitted.
Now, Ms. Geller, because that loading dock was outside of that blue shaded area, was it under Chimes's control?
Absolutely not. We were only leasing the crosshatched portion that we saw in blue.
Now, did your employees ever use that area where the loading dock was?
Yes, we did use it, or my employees used the area.
What did they use it for?
Throw away trash. We were able to use it as a loading dock, and they could use it for other purposes. I'm sure it wasn't really our property, so Kermit was in control of it.
Now, when you say it wasn't really your property, why did you still have access to use it if you wanted to?
Well, we were able to use it as a loading dock.
And was it a common area?
Yes, it was a common area under the lease.
And how does the lease define a common area?
I don't know the specific language from the lease, but or I don't recall the specific language from the lease, but essentially common areas were controlled by Kermit, but we were able to use them.
And could other tenants in the shopping center use common areas as well?
Yes, they could.
So did that mean they could use the loading dock if they wanted to?
Yes.
And according to your lease, who's responsible for maintaining common areas?
Kermit, the landlord, was in charge.
Ms. Geller, I'm showing you section 6.3 of your lease. Can you read what this says?
Yes. Landlord shall be responsible for the good and safe operation, management, and maintenance of the common area. And landlord shall operate, manage, and maintain the common area in good, attractive, and safe condition during the lease term.
And where was the plaintiff when she was injured?
In the common area.
Did she fall off of the loading dock?
I believe so, yes.
Thank you, Ms. Goja. You can take that down. So now, Ms. Geller, I want to talk more specifically about that loading dock. We've heard some witnesses claim today that that back area isn't a loading dock. So as the store owner, what was that space used for?
It was a loading dock.
And why is that?
That's what we used it for, and Kermit even removed the rails for us to be able to use it for that.
And you said earlier that you use the loading dock to get deliveries. Is that right?
Yes.
Now, what type of things do you get delivered there?
All of our merchandise would come in through that back door. We would load them off the trucks into our store, the merchandise that we sell.
Now, if that loading dock had guardrails on it, would you still be able to receive those deliveries?
No.
Why not?
I mean, with the guardrail, it would kind of impede our ability to load the merchandise off the trucks into our store.
Now, is that loading dock used for other purposes?
Yeah, it is.
And what are those purposes?
I presume any purpose that, you know, they could be used by lay people or whoever wants to use it, other tenants.
You said it can be used by lay people. Does that mean that non-employees can use that area?
Yes, I presume they can.
Now, does your lease indicate who's responsible for maintaining loading areas?
I don't recall loading areas, but common areas definitely.
Well, Ms. Geller, I'm going to show you section 6.1 of your lease.
Okay.
Can you tell us what the title of this section is?
Use and regulation of common areas.
And can you read the first couple lines of this section through the phrase lighting facilities?
Yes, the term common area is defined for all purposes of this lease as that part of the shopping center intended for the common use of all tenants, including among other facilities, as such may be applicable to the shopping center, parking areas, private streets and alleys, landscaping, curbs, loading areas, sidewalks, malls, and promenades, enclosed or otherwise, lighting facilities.
Do you consider your loading dock to be a loading area?
Yes,
And do you consider the lighting above that loading area to be a lighting facility?
yes.
And according to this section, who was responsible for the loading area and the lighting facility?
The landlord.
Finally, Ms. Geller, I want to talk briefly about the plaintiff's conduct. Did Chimes make the plaintiffs take a smoke break on January 23rd?
Absolutely not.
Did you hear her say earlier that she sometimes smokes in her car?
Yes.
Would Chimes have stopped her if she had gone to do that?
No.
And did Chimes force her to go around the half-open door?
No.
Thank you, Ms. Geller. Pass the witness, Your Honor.
Mr. Hobbs, you can proceed when you're ready.
Yes, Your Honor. Ms. Geller, you talked a lot about that lease during your direct examination. Do you still have that lease in front of you right now?
Yes, if you would just give me the number, I think I can have it.
I believe it's Exhibit 11.
Okay, yes, I do have it.
Ms. Geller, can you show me where Jordan Gilman's name appears in this lease?
Objection. Relevance.
Your Honor, this goes directly to whether or not the defendant was in control of this space. It's their contention today that Jordan Gilmore should have known about this dangerous area. They've put at issue her own negligence in this case, Your Honor, as an affirmative defense. This goes directly to show that Jordan Gilmore, she's not on this lease. She doesn't have any knowledge of any of the contents of this lease, and she's not bound by any of the terms of it. Who's bound by the terms of this lease is the defendant.
May I respond, Your Honor?
Yeah.
Whether or not the plaintiff was party to this lease makes absolutely no fact here more or less likely. We are contending that Jordan Gilmore was negligent because she actually used this space on a daily basis and therefore knew what it looked like and knew what the apparent risks are. This lease has nothing to do with that. Therefore, whether or not Jordan Gilmore is included on this lease is not relevant here today.
May I briefly respond to that, Your Honor?
Briefly.
Yes, Your Honor. Their contention today is that Kermit Realty Group was the proximate cause of the plaintiff's injuries, of my client's injuries on January 24th, 2019. And because of that, the fact that her name was not on this lease goes directly to their responsibility and their causation of the plaintiff's injuries, which is what the defense is contending today.
Your Honor, first of all, that's not what we're contending. We are contending that the plaintiff is failing to prove their case because they cannot prove control of this area because the area was actually controlled pursuant to the terms of this lease by Kermit Realty. We are not, nor do we have to, claim that Kermit Realty did anything to cause the plaintiff's injuries. In fact, it is the plaintiff's burden to prove by a standard of more likely than not that things that my client, Chimes Department Store, did or did not do are what caused those injuries. Second of all, Your Honor, there's still nothing has been said as to why this lease has anything to do with the plaintiff. The fact that the plaintiff is not a party doesn't make any fact here more or less likely. Of course she's not a party. She was an employee. She didn't own the store. So there's no reason that she would be a party to this lease.
I'm going to overrule.
Back to my question, Ms. Gellers, can you show me where in this lease Jordan Gilmore's name appears?
No, I can.
Now, I want to talk about something else that you spent a lot of time on your direct examination talking about. You told us that your company's lease and the relationship you had with Kermit Realty. Now, the landlord, Kermit Realty, they don't employ any of Chime's employees, do they?
No,
Miss Gilmore wasn't an employee of your landlord.
no,
And with respect to what you're referring to as a loading dock, it was directly outside the emergency exits of your store.
It was directly outside the store, yes, outside the crosshatch portion on the lease.
And you asked to make changes to that elevated platform, didn't you?
Kermit, yeah, I asked Kermit to make changes.
And when you asked them to make those changes were made, weren't they?
Yes,
You've never heard of any other person or entity using that space since your business moved there in 2005, have you?
I don't know if they use the space, but we use the space.
I understand you don't know, but you've never heard of anyone using that space before other than you and your employees. Isn't that right?
Yes,
And you were also responsible and told your employees to make sure that area was cleaned up.
well, we have a dumpster out there, so I tell them to throw trash away in the dumpster.
You didn't ask your landlord to clean up that area, did you?
I don't know what occasion, but I know that the lease says that they are responsible for cleaning the area, and then we just tell our employees to throw the trash away in the dumpster.
Ms. Geller, I understand you want to talk about what the lease says today, but you never asked them to clean up that space behind the building, did you?
I guess not.
Now, I want to move to what your business did in 2005. You moved to that current location in 2005.
Yes,
And we already talked about that request you sent to your landlord. You'd recognize that email if I put it before you today.
yes,
Can you turn in your exhibit book to exhibit 13?
yes,
That's the email you sent to your landlord, isn't it?
yes.
It hasn't been changed or altered in any way since the last time you saw it?
No,
Your Honor, at this time, plaintiff moves to enter exhibit 13 into evidence.
Any objection?
No objection, Your Honor.
So admitted.
Now, in this email, you asked for the railing to be moved ASAP, didn't you?
yes,
And when you asked, that railing was removed almost immediately.
yes,
Now, the incident that we're here talking about today, that's not the first time that somebody has been injured on that elevated platform and stairwell, is it?
no,
5 years after you had that railing removed in 2010, one of your employees was injured walking down those same stairs.
yes,
And in fact, that injury also happened in January.
yes,
And that injury happened while the employee was taking out the garbage.
yes,
And you know that employee blamed it on poor lighting and cracks in the concrete.
yes,
And your manager's recommendation to that employee was that they should not go out at night, wasn't it?
yes,
You didn't have that railing fixed, did you?
no,
You didn't have those stairs fixed?
no,
You didn't attempt to have that light fixed either.
no,
And you didn't ask Kermit Realty to fix any of those issues that you were aware of, did you?
no,
And you didn't do that because you didn't think it was your job to do that.
yes,
I want to move on to what happened to Miss Jordan Gilmore. In 2019, you still didn't have a railing on that stairwell or elevated platform, did you?
No,
You still hadn't fixed the light so that you could operate it from your own business.
no,
So when Jordan was doing what she was told to do and smoke out by the dumpsters, there was no light on, was there?
no,
There was no railing on that platform.
no.
Could you turn to Exhibit 10 in your trial notebook at this time? Now, this exhibit is another incident report that was filed after Ms. Gilmore's fall. Isn't that right?
Yes,
And Ms. Gilmore told you the same thing that that other employee did almost 10 years ago. If the lights would have been on, I probably wouldn't have fallen. Isn't that right?
yeah, she told me that.
And your manager's advice to Ms. Jordan was to quit smoking, wasn't it?
Yes,
And again, to not go outside when that light was off.
yes,
Your Honor, at this time, I intend to go into evidence of the light switch, and we would be using that evidence to show not that the plaintiff could have fixed the light switch, but that they should have fixed the light switch, and that they in fact did move that light switch, exercising control over that area of the space and exercising ownership over that light switch.
May I respond, Your Honor?
Yes.
Your Honor, this is exactly the issue that 407 is meant to preclude. There has been no contention on the part of Ms. Geller that they couldn't, that feasibility was an issue. There has to be an issue of either control or feasibility in order for this to be admissible. Otherwise, it is a subsequent remedial measure and it is prohibited under 407. On the facts alone, there's no issue of control. The fact of the matter was, at the time, they didn't have control over the light. They cannot say that because a light switch was subsequently installed, that means that they had control before, because they didn't, because it's the light switch that gave them control. So to say anything else is a question of feasibility that Ms. Geller has not put an issue here today. Therefore, this is still not admissible. No door has been opened.
Brief response to that, Your Honor.
Briefly.
Yes, Your Honor. It's the plaintiff's contention today that when an OSHA inspection was conducted on these premises, a manager of the defendant told that OSHA inspector that that light was automatic. And in fact, the plaintiff knew, or the defendant knew, and the defendant's managers knew that that was not the truth. And because of that, Your Honor, we have to go into this evidence today because it shows that the defendant knew that that light switch didn't come on and that they lied to an OSHA inspector. And as a result of that, they did not receive a citation.
May I respond, Your Honor?
Briefly.
All of that evidence can be elicited without going into this subsequent remedial measure. We've already heard that light, they did not have the ability to turn that light on prior to this incident. We anticipate that we will hear as an offer of proof via the deposition of Perry Hayden, the OSHA inspector, that when he asked the manager about that light, she made certain representations to him, and counsel is free to argue that that was not the truth. None of that implicates the subsequent installation of this light switch.
I agree. So you have to stick to the issues that you've outlined, no mention of the subsequent moving of the light switch, as we just discussed before.
Yes, Your Honor. Ms. Gellers, the last thing I want to talk to you about today is that light behind your store. And we've heard from chimes that it was my client was injured. That light couldn't be turned on from inside your store.
that's right.
And you were visited by an OSHA inspector 7 months before my client was injured.
Yes,
And you're aware that you passed that OSHA inspection.
yes,
Now, could you turn to Exhibit 36 in your trial binder?
yes,
Now, at the top of this page, it says U.S. Department of Labor.
yes,
And there's a seal on this document.
yes,
And underneath that in large print, it says inspection report.
yes,
Now, I want you to turn with me to the second page of that document. And there's a paragraph near the top where the OSHA inspector was asking about the light in the back of that store. Are you there with me?
Objection, Your Honor. This is not in evidence, and we believe that plaintiff's counsel will not be able to lay sufficient foundation with this witness to offer this exhibit.
Counsel,
Your
do you-
Honor, I haven't offered this into evidence yet. I can do that at this time, Your Honor. I've not elicited any statements from it yet. When I do, and as offering it into evidence, Your Honor, every piece of evidence in this case packet has been stipulated as authentic and original. That foundation has just been laid by this witness. He doesn't need to have, or she doesn't need to have personal knowledge of the contents of this statement. She can read them right now and have personal knowledge in the courtroom today of those statements. We've laid sufficient foundation to support a finding that this evidence, this exhibit right here, is an official document of the United States government Department of Labor.
And so, counsel, can you tell me what exhibit number this is?
Yes, Your Honor, this is exhibit 36.
Okay. And so are you offering it into evidence at this time?
Yes, Your Honor, I am.
And Ms. McGuigan, any objections to offering it into evidence?
Yes, Your Honor. We object that sufficient foundation has not been laid. Ms. Geller has never seen this report before. There's no indication that she is familiar with the contents of this report. She is not the employee of Chimes Department Store that accompanied the inspector during this inspection. As such, we have not had any foundation for the contents of this report so that the jury may hear them at this time.
Brief response to that, Your Honor.
Yes.
Your Honor, it's been stipulated in this case that every exhibit is authentic and original. The only time that we need to lay foundation that a witness has personal knowledge or has been given this report beforehand is whenever we're authenticating an exhibit, and it's already been stipulated between the two parties in today's case. Because of that, Your Honor, defense counsel has also had access to this document, and they've been able to show it to the defendant at any point in time. If they've not chose to do that, that's their own personal choice, Your Honor. At this point in time, we've laid sufficient foundation, and it's been stipulated to that this is an authentic exhibit, and therefore personal knowledge of its contents is not necessary, as that personal knowledge is only necessary to lay that foundation for its authenticity, and that's already been stipulated to.
I'm going to overrule the objection, and the exhibit 36 is admitted.
Now, moving to exhibit 36, that second page of the exhibit, there's a paragraph at the top, and there's a sentence that starts with "so." And that sentence says, "So I next asked her whether the light on the wall would be turned on when employees were out there at night." And Ms. Geller, could you read that next sentence to the members of the jury today?
She told me that she thought the light automatically came on at night. So it would always be on when she was out there.
And you know that that's not true today. Isn't that right, Ms. Geller?
Yes.
No further questions, Your Honor.
Redirect.
Yes, Your Honor. Ms. Geller, can you repeat what that line you read just now said?
She told me that she thought the light automatically came on at night. So it would always be on when she was out there at night.
Did she say she thought or that she definitely knew?
She thought.
Okay, Ms. Geller. And then you were asked on cross-examination about whether there were railings on that loading dock. Why didn't it have any railings?
Kermit removed them.
And can you have railings on a loading dock?
No, you can't have railings on a loading dock
Why not?
because it completely destroys the use of the loading dock.
Thank you, Ms. Geller. No further questions, Your Honor.
Okay, if we're done with this witness, Ms. McGuigan, you can move to your next one.
Your Honor, at this time, the defense calls Perry Hayden by deposition pursuant to Federal Rule of Civil Procedure 32. Beginning on page 2 of Perry Hayden's deposition, line 5. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Perry Hayden.
Moving to line 11. What do you do for a living?
I am a compliance, safety, and health officer with the Occupational Safety and Health Administration.
What does the Occupational Safety and Health Administration, or OSHA, do?
OSHA is the government agency that is responsible for making sure that workplaces are safe for the employees that work there.
Moving now to line 22. And what do you do at OSHA as a compliance, safety, and health officer?
I'm one of the people from OSHA that goes out and inspects workplaces on a regular basis to see if that workplace is in compliance with OSHA standards.
What happens if a workplace doesn't comply with those OSHA standards?
Well, there are lots of potential implications, but at the very least, it would result in a citation for any violations that we find.
Moving now to line 16. How long have you worked for OSHA?
Since I got out of school. So at this point, that's about 13 years.
And over that time, how many inspections have you conducted?
Oh man, hundreds, thousands? I mean, the answer is a lot. It's basically my entire job. So I'm always out on the road inspecting somewhere. It's an everyday thing.
Moving now to page 4, line 14. How did you end up being involved in this case?
I got a subpoena from you and it told me to show up here, so that's what I did.
Moving now to page 5, line 1. Are you being paid by anyone for your time here today?
Nope,
Have you been retained by anyone to serve as an expert in this case?
nope.
All right, Ms. Hayden, how are you involved in this case?
Well, I conducted an inspection at that Chimes department store in Waco back in 2018.
Moving now to line 16. Why did you inspect the Chimes department store in Waco back in 2018?
It was just a regularly scheduled inspection.
Moving now to line 23. During that inspection, what were you looking for?
At the most basic level, I'm looking for any kind of condition at the workplace that might be dangerous to the employees working for Chimes.
How do you determine if a condition is dangerous?
Well, if a condition on the premises doesn't comply with the standards under the OSHA regulations, then it would be dangerous, and that would necessitate a citation.
Did you issue any citations to Chimes as a result of your inspection back in 2018?
No, I did not.
Did you inspect the area behind the store where there's a little landing area and some steps?
Yes, I did.
Moving now to line 22. When you went out there, what did you notice about the steps and that landing area?
Well, at first I was a bit alarmed because there were some pretty obvious issues.
Like what?
Well, there were stairs in a landing area, but there were no guardrails anywhere. Plus, the concrete on the edges of those steps and that landing were cracked and eroding away. Someone with half as much experience as me could look at that and see some pretty obvious problems.
And if there were such obvious safety issues, why didn't you issue any citations?
As I said, I got pretty alarmed, so I asked the manager that was walking around with me during the inspection about the fact that there were no guardrails and about the cracked concrete. The manager told me that there used to be guardrails, but they were removed because Chimes used that landing area as a loading dock.
Why does that matter?
Because loading docks don't have to have guardrails.
How do you know that?
Because OSHA says so.
Moving now to page 8, line 20. Is there any OSHA regulation that does specifically discuss loading docks?
Yes, 1910.28B13 clearly states that guardrails aren't required on loading docks because they aren't feasible. You can't very well load something onto a dock with a bar in your way.
Moving now to page 9, line 3. Well, what do you have to say about all of the OSHA regulations that Kelly Danes testified were violated by the defendant because of the condition of that landing area in the back of the store?
I'm sure Miss Danes is a very nice person, but they're just reading those regulations too broadly. None of them deal with loading docks, which is what Chimes was using this area as. This wasn't just a stairwell or just a landing area at the top of a stairwell. This was a loading dock, and the provisions cited by Kelly Danes don't deal with loading docks.
Was this area behind the store exclusively used as a loading dock?
No. It's my understanding that employees also went out there to throw trash in the dumpster and to take breaks. And it is certainly possible that employees went out there and did other things as well. But I don't think that matters.
Why not?
Well, just because an employee goes out and sits on the edge of a loading dock and eats a sandwich doesn't make that loading dock a diner. The key thing here is that Chimes used this area as a loading dock. That's what matters.
Your Honor, this concludes our read-in portions for Perry Hayden at this time.
Thank you. Mr. Hobbs?
Your Honor, before I begin my cross-examination, I would like to ask Ms. Combs to put I believe that it is the specific OSHA regulation that was mentioned during the direct of this witness that dealt with the railings around a loading dock. Ms. Combs, if you could put that up for me. When the employer can demonstrate that the use of fall protection systems is not feasible on the working side of a platform used at a loading dock, loading rack, or teaming platform, the work may be done without a fall protection system provided. A, the work operation for which fall protection is infeasible is in process. B, access to the platform is limited to authorized employees. And C, the authorized employees are trained in accordance with section 1910.30. And with that, Your Honor, I will begin my cross-examination of this witness by deposition. Starting on page 6, line 4. How do you determine if a condition is dangerous?
Well, if a condition on the premises doesn't comply with the standards under the OSHA regulations, then it would be dangerous, and that would necessitate a citation.
Moving to page 6, when you went out there, what did you notice about the steps and that landing area?
Well, at first I was a bit alarmed because there were some pretty obvious issues.
Like what?
Well, there were stairs and a landing area, but there were no guardrails anywhere. Plus the concrete on the edges of those steps and that landing were cracked and eroding away. Someone with half as much of experience as me could look at that and see some pretty obvious problems.
Moving now to page 9, line 23. Ms. Hayden, I'm showing you what has been marked as Exhibit 38. Do you recognize this?
Yes, this is an email that I received from one of my superiors in May 2019.
Moving now.
As to hearsay in that email.
Your Honor, I'm not offering any of the contents of the email at this time.
Okay, we'll overrule at this time.
Moving now to page 10, line 5. Do you disagree with the assessments of your boss in this email?
No, I don't. I am fairly conservative when it comes to issuing citations.
Your Honor, we're now discussing the contents of that email.
Your Honor, we're not discussing any of the contents that were contained in that email. We're discussing this witness's reaction to the contents of that email. That has nothing to do with any hearsay, and these statements are being brought in as an unavailable witness today and therefore are not hearsay.
Do you intend to offer the contents or discuss the contents of the email?
No, ma'am. I'm merely asking this witness about her reaction to the contents of that email.
Ms. McGuigan, any response?
Yes, Your Honor, just that asking her opinion on the contents, it implicates the contents of the email, which are hearsay from this witness's employer.
Yeah, I'm leaning in that direction as well. I'm not sure the purpose of offering or asking about the contents of the email and not offering them.
Your Honor, I'm not eliciting any of the statements contained in that email. I'm eliciting the response of this witness to the contents of the email. These are the statements that were taken during this witness's deposition, and this witness has been deemed unavailable under Rule 804.1, and this is a prior deposition or sworn statement that was given an opportunity for cross-examination. Therefore, it falls under a hearsay exception, as I'm not eliciting any of the hearsay statements or out-of-court statements that are now being used to assert any sort of truth. I'm not asserting anything about those statements because I'm not asserting those statements.
I'll overrule.
Moving to that line 5 on question or on page 15, do you disagree with the assessment of your boss in this email?
No, I don't. I am fairly conservative when it comes to issuing citations. Look, I obviously believe that workplaces need to be safe for employees, but that doesn't mean the government should be draconian in enforcing those regulations, especially in times like these when it's hard enough to find a job or a place to work. So maybe I'm a little bit more lenient than other inspectors. That's certainly possible.
Moving now to page 11, line 4. Do you have any opinion about who was in control of that area behind the chimes, whether it was chimes or the landlord?
Nope. That's way out of my bailiwick. I
Objection,
mean,
objection, Your Honor, outside the scope of this witness's expertise.
Sustained.
Yes, Your Honor. I'll move down to line 18 on that same page. Did you notice a light out there whenever you were doing your inspection?
I did. You'll see it noted in my report.
Did you ask the manager about that light?
I did, like you can see in my report.
And what did that manager say?
The manager told me that they always turn the light on when someone goes out back at night. So that seemed good enough for me.
Your Honor, I have no further questions at this time.
Any redirect?
Yes, Your Honor. Going back to page 10, beginning at the end of page 10. I'm sorry, at the end. Your Honor, for the purposes of completement, we're going to read the entire question and answer. A portion of it was read on cross, but we want to read in the entire answer. So we're going to begin on line 5 on page 10. Do you disagree with the assessment of your boss in this email?
No, I don't. I'm fairly conservative when it comes to issuing citations. I obviously believe that workplaces need to be safe for employees, but that doesn't mean that government should be draconian in enforcing these regulations, especially in times like these when it's hard enough to find a job or a place to work. So maybe I'm a little bit more lenient than other inspectors. That's certainly possible. But I do my job and I do it well. And we talked about this issue and it was all good. It's not like I've been fired or anything.
Nothing further from us for this witness, Your Honor. And Your Honor, with that, the defense rests and we renew our mid-trial motion as the plaintiff at this point has still not made a showing on which a juror could find by a preponderance of the evidence that Chimes Realty actually controlled that loading dock and therefore had any responsibility to maintain it.
I'm going to deny the motion. And we'll move into closing arguments.
Before we proceed to closings, Your Honor, may we have a brief 5 to 10 minute recess?
Let's go with 5.
Yes, Your Honor.
Okay, thank you.
And may we also have a time check, Your Honor?
Yes, so Ms. McGuigan, you are at 20, you have 23 minutes remaining, 23:12. Mr. Hobbs, you have 12:23.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, everybody ready to proceed with closing?
Yes, Your Honor, the plaintiff is ready to proceed.
All right. So, Mr. Hobbs, you may move forward when you're ready.
Before I begin, Your Honor, I'd like to reserve 2 minutes of my 12 minutes remaining for rebuttal.
Okay.
May it please the court. Your Honor, opposing counsel, members of the jury. Dark, derailed, dangerous. That's what you've heard about today. January of 2019, Jordan Gilmore, an employee of the defendant department store, was told to go out into a dark stairwell, onto a derailed platform, into a dangerous condition the defendant knew about. But our story doesn't begin in 2019. Members of the jury, this story began in 2005 when the defendant asked Kermit Realty Group to remove the railing ASAP, and that was done. 5 years after that, an employee was injured while working out in that area because there wasn't enough light, there wasn't a railing. And in 2018, an OSHA inspector asked about that light and was told, oh, well, it's an automatic. And that brings us to January 23rd of 2019, when Jordan Gilmore was where her employer told her to be on their premises if she was going to smoke. When she had to walk up those dark stairs on their premises. When she had to step onto that derailed platform on their premises. When the defendant created a danger on their premises. Members of the jury, as the plaintiff in today's case, we carried the burden of proof. And we've met our burden throughout today's trial. We've shown you that the plaintiff fell as a result of the defendant's actions. The defendant knew about the dangerous condition. They didn't do anything to correct that dangerous condition. And that condition posed an unreasonable risk to the employees that they are responsible for looking after. So let's walk through each one of those different elements today. And by the time I'm done up here, I am sure that when the judge charges you as the members of the jury, you'll know who is liable. You'll know that the defendant, Chimes Department Store, is liable. So let's take that first element. You heard today that the condition was dangerous and it created an unreasonable risk. And we've shown you that in 3 different ways. You've heard today from our own expert about the responsibilities that an employer has to look after their employees when they are conducting their business on the premises. They're also responsible for the areas around the premises, according to those OSHA regulations. You've heard today that the lighting that was outside of that store on multiple different occasions, at least 2 that we're aware of today, caused somebody to fall and hurt themselves. Once in 2010, over a decade ago, and again in 2019. You're going to have a chance to look at those regulations whenever you go back into the jury room. And you're going to see that entrances and exits, they have to be clearly lit at all times, that employees are inside of the building. And that brings us to the second way we prove that to you today. We've proven to you today that this platform, regardless of whatever the defendant wants to call it, it wasn't a loading dock. It was an elevated platform that was used for multiple different uses. That employees were told to use it for multiple different uses. Take out the trash, use it for your smoke breaks, take deliveries there. Members of the jury, during today's trial, you had an opportunity to hear about that OSHA regulation that governs loading docks. The defendant didn't meet a single one of those requirements for them to not have a railing on that loading dock. They didn't have the work operation in progress when the plaintiff fell. They didn't have authorized personnel on that landing when the plaintiff fell. And we've heard nothing today at all about any training that was conducted on behalf of the employer.
Assumes facts, not in evidence. May I be heard, Your Honor?
Briefly,
Opposing counsel never asked Reese Geller, much less anybody else, whether there was any training. Therefore, he cannot now argue affirmatively that there was not any training.
Your Honor, what I said was we've heard nothing today about any training.
let's keep it that short.
Yes, Your Honor. Now, we've established that there was an unreasonable risk of harm in that area. And we've also established that the defendant knew about it. You heard about that prior injury today. You heard the testimony of the defendant's own manager. It's our space. Should have fixed those stairs a long time ago. Sorry about that. Members of the jury, you've also heard today from our expert who told you that anyone who saw that deck knew that there was an issue. In fact, the OSHA representative told you that today. We've proven to you that Chimes Department Store knew about that risk. And that brings me to the third thing. Members of the jury, they did nothing to fix this issue. In fact, they created it. They asked somebody to take the railing off of that platform. And members of the jury, you don't get to ask to dig a pit behind your property, pay somebody else to do it, and then, oh, when somebody falls in, it's not my responsibility. That's not how that works, members of the jury. That's not common sense. We've also proven to you today that it was the inactions of the defendant in failing to fix the light, in failing to fix the railing, in failing to ask Kermit Realty to do anything about any of those issues. That was the proximate cause of the plaintiff, Ms. Jordan Gilmore's injuries. We've shown you today that it's foreseeable that with a dangerous, dark, and derailed platform that the defendant created, it was foreseeable that somebody could get hurt. And in fact, that Ms. Jordan Gilmore did. Now, as the plaintiff in today's case, we weren't the only ones with the burden. The defendant also had a burden today.
Objection, Your Honor, counsel's burden shifting. May I be heard?
Yes.
Your Honor, counsel is instructing on the law who has the burden here today. That is specifically Your Honor's prerogative. And per Your Honor's jury instructions, no burden whatsoever has been assigned to the defense here in this case. The plaintiff bears the burden at all points in this case.
May I respond, Your Honor?
Response.
The jury verdict form that the defense chose to use in this case asserts the affirmative defense that it was the plaintiff's actions that caused this injury, and it asserts that it was the responsibility of Kermit Realty Group. They have to establish both of those by a preponderance of the evidence today because of the jury verdict form that they've chosen to use.
May I respond, Your Honor?
Briefly.
That is an incorrect summary of the jury instructions. We did assert an affirmative defense. However, there has been no burden imposed in accordance with that defense. Therefore, the burden remains with the plaintiff both to prove the elements of negligence by a preponderance of the evidence and additionally to disprove the affirmative defenses that we have asserted here today.
Your Honor, that's not how the law in this jurisdiction works.
I'm going to overrule the objection.
The defense has a burden to prove to you today. And they've done nothing at all to tell you about that burden, to prove that burden, or to put any evidence before you today that they have met their burden by preponderance of the evidence to show that either my client, the person who was injured, was responsible for her injuries, or that Current Realty Group was responsible for her injuries. The first thing that they've tried to show you today is that they're not negligent. But we know that the OSHA report that was filed that said, oh, there's no problems here, was based on a lie. They told you, the defense told you today, oh, that's an automatic light. Members of the jury, we know that is not true. And it was because of that that no citation was issued as a result of that OSHA visit.
Counsel, you're very close to 2 minutes.
Yes, Your Honor. We also know today that that is not a loading dock. We know that that dock was used for multiple different purposes. And the defense is going to get up here in a few moments, and they're going to show you and put on a lot of evidence about a lease, trying to say that they weren't in control. Members of the jury, they are in control of their own employees. They control their actions when they are at work. So that word control, they're going to try to distract you with it. And finally, they're going to try to argue that when they dug a pit in the back, that they caused that injury to happen. That was Jordan Gilmore's fault. Dark, derailed, dangerous. Find the defendant liable. Thank you.
You'll have up 1 minute, 30 seconds for rebuttal.
Yes, Your Honor. Thank you.
Your Honor, I'm just going to set up the courtroom very quickly.
Sounds good.
Your Honor, can you hear me okay?
Yes,
May I proceed?
you can.
Members of the jury, in opening statements, I told you that by this point, you would know 3 things. First, that the landlord, not Chimes department stores, controlled the loading dock where the plaintiff fell. Second, that none of the regulations you heard about today actually apply to that loading dock. And third, that the plaintiff's own choices are what actually caused her injuries. Members of the jury, today, the evidence has shown that Kermit Realty LLC, the landlord, controlled that loading dock, and the plaintiff controlled her own choices. Chimes department stores had nothing to do with it. No control, no responsibility, no liability. So let's walk through what you learned today. Now, the very first thing that the plaintiff had to show you was that Chimes department stores controlled this loading dock, and they failed to do that. They've said over and over and over again that this was Chimes's premises, but members of the jury, repetition is not proof. They had to prove to you that Chimes controlled that loading dock, because if they don't, they're not responsible for keeping it safe, and this case is over right then and there. So let's talk about the evidence that you did see. We showed you Chimes department stores' lease for the space that they actually control, that they actually have a responsibility for keeping safe. And we showed you that according to this lease, common areas are not the responsibility of the tenant. They are the responsibility of the landlord. And then we showed you the site map that was attached to their lease. And it shows that the area that Chimes actually controlled, the area they rented, the area outlined in blue, It doesn't include the loading dock that brings us here today. That loading dock was in a common area, so that loading dock was controlled by the landlord. Any number of tenants in that strip mall could have used this loading dock. That makes it common space. And the simple circumstantial fact that other tenants didn't use that space, that doesn't make it not a common area. The lease says that it is a common area, which means that it was not the responsibility of Chimes department stores. And it's true that Chimes department stores did use that space. They were a tenant. They were allowed to use it just like anybody else. But use alone without more does not equal control. The plaintiff has not shown you control, so this case is over right then and there. Because without control, there can be no responsibility and no liability. Now, even so, the plaintiff also didn't prove that there was actually anything wrong with the way that area was maintained. They brought you Kelly Danes, a paid mechanical engineer who they tried to tell you was an expert in inspection and performed an inspection at this site, but that's not what she did. She performed an investigation after she was hired, members of the jury. And she told you all about OSHA and IBC regulations that said what? Guardrails have to be used on loading docks. Members of the jury, they showed you IBC 1021. I'm sorry, we showed you IBC 1021 because they didn't. Because they wanted you to hear that their experts said that it meant that this platform had to have a guardrail. They neglected to tell you that it specifically has an exception for loading docks. Because they didn't want you to see that meant that this loading dock was exempt from this requirement. And members of the jury, that makes sense because a loading dock, as you heard, can't have handrails. How can you accept massive deliveries on a platform that requires you to hoist things up and over? It doesn't make any sense. That's specifically why the IBC and OSHA regulations exempt loading docks from having these railings. And that's why this loading dock didn't have them. You heard that when Chimes moved into that space in 2005, they asked Kermit, the landlord, to remove those railings so that they could use it as a loading dock. And that's how they've used it ever since. Yes, employees walk out on that loading dock to go throw out trash and take their smoke breaks, but that doesn't make it not a loading dock. And before we move on, I just want to address something that counsel said a couple times on their closing. They said that Chimes can dig a hole, but then they're responsible if someone falls into it. Now, I didn't hear anything about a hole being dug today, did you? I just wanted to clarify, don't let them distract you by trying to claim that the changes that were made to that platform to make it a loading dock were anything more than they actually were. And what they actually were was removing some railings that changed the nature of that platform and made it exempt from the regulations that they brought you today. Now, they didn't bring anything else here to prove otherwise. All they brought you was Kelly Danes claiming this wasn't a loading dock without any foundation to prove it. That's not good enough, members of the jury. So it's not good enough to meet their burden. Now we, on the other hand, brought you Perry Hayden, an actual OSHA investigator who actually has expertise in these regulations and whether or not they are violated in certain circumstances. And she explained to you that in 2018, she went to Chimes department store to perform a routine inspection. She saw everything that the plaintiff claims made this platform so dangerous. She saw the concrete, she saw that there were no railings, and at first she was a little alarmed. But then everything was fine when she was told that this was a loading dock, because as you heard her say, all of the OSHA regulations that came to mind when she saw that platform, they no longer applied. That's why there were no citations issued, and it was perfectly reasonable for Chimes department store to rely on those conclusions. How is a department store supposed to look at the conclusions made by an officer of a federal agency and say, well, that must mean that somehow our space still isn't safe enough? Members of the jury, that doesn't make any sense. So when the plaintiff tells you that Chimes knew or should have known that this area was dangerous, remember that the federal government told them that it was up to code, and it was reasonable for them to rely on that. Now, in response to this, the plaintiff has tried to undermine the credibility of Perry Hayes and show that she was lenient in issuing citations. But members of the jury, as you heard, she hasn't been fired. She still has her job. She was still able to, by deposition, come and provide the results of her investigation here today. So when you hear that, know that it's an inconsequential distraction. The plaintiff focused on the light outside of this area. Plaintiff would have you believe that the manager of Chimes department store outwardly lied to Perry Hayes. But members of the jury, when you heard the portions of the testimony, you heard that that manager said, "I think this light can be turned on." That's not somebody outwardly lying. That's somebody making a mistake in what they said. So you have the record of this trial. You can go back and look at that when you deliberate. We ask that you do and hold the plaintiff to what they are trying to misrepresent here today. Now, members of the jury, the plaintiff also talked about a previous incident on these stairs, and we don't dispute that that happened. But that was one fall 9 years ago. 2 falls in 9 years is not evidence of unreasonable danger. It is evidence that sometimes people fall, even in reasonably safe workplaces. The fact that 2 people fell 9 years apart doesn't mean that any regulations were violated or that anything was unreasonably dangerous. It just means that sometimes accidents happen. So hold them to their burden. Don't let them present you with one previous incident and then lean on that to meet that burden. Members of the jury, Chimes department store didn't control that platform. Because they didn't control it, they had no responsibility. But even if they had, the plaintiff has proven no violations. So they've proven no liability anyway. No control, no responsibility, no liability. And members of the jury, today you learned one more thing. The unfortunate truth that Jordan Gilmore's own choices are what actually caused her injuries. Now, we're not saying that Jordan is anything other than a good woman. And we understand wanting to find someone responsible when you get hurt. It makes sense. But today, members of the jury, your job is to determine whether Jordan acted as a person of ordinary prudence would in her circumstances. And the evidence has shown that she didn't. It was dark, it was cold, and she went outside to go smoke. You heard her say that she sometimes smokes in her car. She could have chosen to do that. She could have chosen to go off the premises, but she didn't. She chose to go outside. She went down the stairs, and she smoked a cigarette. And when she came back up, she could see that that door was half open. She could see how little space she had to get around the door. And she chose not to ask Riley to open it all the way. She chose not to ask Riley to move out of the way. She chose not to ask Riley to close the door. She tried on cross-examination to claim that she didn't remember any of this. Despite saying on direct, "I can never forget that day. It was 2 days before 1 month after Christmas." She tried to pretend she didn't remember, but when I followed up, she did admit she didn't choose to say any of those things. And if she had, she would have had more space on the landing. She could have walked safely up and gone back inside, just like she had time and again for years that she had worked there. But she didn't. Instead, she chose to try to scoot around that door, knowing that she was right on the edge of the loading dock, knowing that there was no railing there, knowing what could happen if she slipped. And unfortunately, members of the jury, she did slip and she was injured. But that's the result of her own choices. Chimes department store had nothing to do with it. Members of the jury, wanting responsibility is understandable. Pitying somebody who's been injured is understandable. But the truth, members of the jury, is that the people responsible for what happened here, well, it's the plaintiff herself. Kermit Realty, the landlord, controlled the loading dock, and the plaintiff controlled her own choices. Chimes department store had nothing to do with it. So when you get to question 1 on the jury sheet about whose negligence caused this accident, you can look at the facts and the proof that you have seen today. And you can answer yes for Jordan Gilmore and no for Chimes department stores. And as for Kermit Realty LLC, well, we suggest you answer no as well, because the plaintiff has not proven by a standard of more likely than not that there was anything wrong with the way that loading dock was maintained.
Objection, Your Honor. Burden shifting. That wasn't our burden in today's case. The defense carried that burden.
Your Honor, the plaintiff absolutely did have to prove that that loading dock was unreasonably dangerous.
I'm going to overrule.
Members of the jury, as I was saying, as for Kermit Realty LLC, we suggest you say no, because the plaintiff hasn't proven that there was actually anything wrong with the way that loading dock was maintained. Regardless of how you answer for Kermit Realty, when you get to question 2 that asks you to apportion percentages of fault, you can confidently answer 0 for Chimes Department Store LLC. They did not have control. They had no responsibility, so they can bear no liability. Find Chimes Department Stores not liable. Thank you.
Rebuttal, Your Honor.
Yes, you may proceed.
Members of the jury, they want to make this case about a contract. They want to hide behind a paper shield. Who controlled? Fine. But this case was about who was responsible for the safety of their employees, and that was Chimes Department Store. They knew about the risk. They didn't do anything to fix the risk. It was dark. The platform was derailed, which created a dangerous condition. When you go back into the jury room, you're going to be confronted with a verdict form. In fact, we agree with defense counsel. Kermit Realty, they're not responsible for what happened. Jordan Gilmore is not responsible for what happened. Find the defendant liable. Mark yes next to Chimes Department Store, because it was a dark stairwell, a derailed platform that created a dangerous condition. Thank you.
Thank you both. Okay, I think at this time we will let the judges fill out ballots. And then judges, I believe, once you have done so, or if you would like to provide comments back to each of the participants, we can do that. So I will just kind of open it up to the other 3 judges. If you want to give comments and you're ready, then please, and you've turned in your ballots, then please go ahead. Any of the other judges want to provide comments?
I'm happy to whenever it's time.
I think you please jump in when ready.
Sure, I'll keep it super short because they told us we had to, and I do whatever Bobby tells me to do. First, you both were great. Thank you. Just so one thing they told us, keep us one thing positive, one thing constructive for each of you. Let me start with the plaintiff. I thought you demonstrated a real solid command of the facts, a real understanding, I think, of a lot of the diversity of different kind of emotional appeals you could make rooting out of the facts. Those were positives, and this will be a constructive statement for both of you, but with a slightly different twist on it. And that is you both need to focus on now how you make choices among the things you find appealing rhetorically and argumentatively. And for you on the plaintiff side, let me just give you one quick example, because this is the type of little stuff that matters a lot to me. When you choose a construct to drive home important terms, like the use of repetition and alliteration, in your case, the dark, dangerous, and derailed construct, you got to make sure you nail it, right? Because you're saying it over and over. It's got to do a lot of work for you. In this case, yeah, I don't know. I'm not sure that construct did enough work for you, even if it was successful. And just a little thing to keep an eye on: derailed. Don't ever push for something you like alliteration at the cost of clarity. Derailed is just not a word that people are familiar with in the context you're using it with, right? The removal of rails. So if it's going to be a rhetorical construct that you say over and over, just think about that kind of stuff, because homonyms matter. Now, on the defense side, I probably no longer count as being very short, so I apologize. But I thought you really stood out in one way that I would emphasize to both, which is that I thought you did a really nice job gatekeeping for your witnesses to help do some protection of your witnesses when they were being crossed. I thought that was good in both. I could have seen even more of it from both of you, kind of being vigilant, protecting your witnesses. And on your side, in terms of constructive, of making choices, and this is going to go against every instinct a lawyer has, be willing to leave time unused if you genuinely don't need it, right? So if you feel yourself being repetitive, if you're not sure, kind of you're ticking off a list of arguments, but you're not even sure why they're important, let yourself end if you feel like you have done your job. And because the last thing you want to do is kind of tack multiple conclusions on and end up pulling away from what you had, which I thought was a tight sense of how to organize your thoughts. So if that's what you're doing, don't water yourself down. But otherwise, both of you were great. Sorry if I was too long-winded. Thanks.
Will or Ryan, please feel free to jump in.
I'll try to make it real brief. Will King here. Plaintiff's counsel, I thought you had a good range of expression. I would just make sure to balance that, kind of like with what Josh was saying, with making sure that there's a correlation between kind of the expressions made and the facts of the case, and that they speak to each other. If there's a disconnect, it can come off as hammy. I'm not saying that you were, but I've seen that a lot, where it's all expression, no facts, and you lose your credibility. Defense counsel, I thought that overall, you're extremely organized and clear. I could follow you. I cannot impress upon you how important that is when you're watching something like this. I like to judge mock trials because it's a reminder to me to get to the point. And you also have great objections. But the only comment I'd give you is just watch out about making too many objections, even if it might be warranted, because that can at times make it appear to the jury like you're trying to hide some sort of fact, or that you're being sneaky. I'm not saying that was necessarily the case, but just make sure to tailor and kind of use your discretion when objecting to something. But the objections were good.
Ryan?
I believe all those comments, I agree with them. I would end with saying that I'm very impressed. I know y'all have a day to figure this out, and your command of the facts and the law and all that stuff in a matter of 24 hours is very impressive, and you should be very proud of yourselves.
And I will briefly end as well. I completely agree with all of the other comments, and I've actually forgotten you only have 24 hours to do this, and that is incredibly impressive considering how well your opening and closing statements were in particular. So I do want to say that I think you both made some good objections, and on top of it, you responded to objections very well. And so that was impressive to me for both of you. You were clear and you were logical in your objections and your responses. And I always get a little nervous being presiding judge because I don't really want to rule on objections. It's just not my nature. But you all did a good job of articulating what you were objecting to and then responding appropriately. So I wanted to give you kudos on that. So that is it from the judges. I guess I think we're supposed to move pretty quickly to get you on to the next round. So thank you for all your hard work.
Thank you all for coming in today. We really appreciate it.
Good luck, everybody.
Yes.
Great job to both of you.
Great
Thank
job.
Thank you. Thank you.
The party's ready to proceed.
Good afternoon, Your Honor. Yes, the defense is.
Good afternoon, Your Honor. The plaintiff is ready as well.
Okay, let's start with introductions and then we can get into substantive and any housekeeping issues y'all have.
Good afternoon, Your Honor. Carolyn McGuigan on behalf of the plaintiff, Jordan Gilmore. Today I'm joined by my co-counsel, Chehet Gojia.
Good afternoon, Your Honor. My name is Lauren Doig, and I represent the defendant, Chimes Department Store, along with my co-counsel, Mr. Aaron Friedman.
Good afternoon, Your Honor.
Good afternoon.
We do have one pretrial matter and a few procedural issues to address with Your Honor whenever you're ready.
Okay, let's take up the plaintiff to see if they have any substantive or housekeeping issues first, then we'll move on to you.
Yes, Your Honor.
Apologies, opposing counsel. Your Honor, we do have a couple housekeeping matters to deal with here today. First, we have met with opposing counsel prior to this trial, and we have agreed to pre-admit a number of exhibits. I can give that list to you now.
That would be great.
Those are exhibits 1, 2, 3, 5, 6, 11, 13, 19, 22, 31, 32, and 36. Next, Your Honor, as defense counsel has informed us, they will be asserting an affirmative defense both against the plaintiff, Jordan Gilmore, and against the owner of the property in question, Kermit Realty LLC. As such, we will be using the first version of the jury instructions that Your Honor provided that lists all three parties, the plaintiff, the defendant, and Kermit Realty LLC, in the jury questions.
Okay, that'll be fun.
Finally, Your Honor, we will be reading in certain portions from various witnesses' depositions today. And on the plaintiff's side, we will be bringing the deposition of Kelly Danes. In the portions that we intend to read in, multiple exhibits are referenced. However, we are only pre-admitting two of those exhibits. They are exhibits 19 and 22 in the list that I just gave you. And therefore, as we have informed opposing counsel, when we get to those lines in the testimony, we will only be saying exhibit 19 as opposed to exhibits 19 through 30, so as not to confuse the jury as to which exhibits they're seeing.
Okay.
Finally, Your Honor, as for substantive matters, we did intend, oh, I apologize, my Zoom is doing something strange. We did intend to make two substantive motions to preclude exhibits 37 and 40. However, those have been granted on consent.
Anything else?
That's all from the plaintiff, Your Honor.
All right, defense.
Yes, Your Honor. First, we spoke to opposing counsel before trial, and we let them know that we're seeking to use Exhibit 2, one of those pre-admitted exhibits, as well as the jury instruction in our opening statement. They had no objection to that, and I just wanted to make sure that's okay with Your Honor if we do publish those during our opening.
That'll be fine.
And second, Your Honor, we just have one pretrial motion. It sounds like with my discussion from opposing counsel that we'll be able to come to an agreement on this, but they did want this before the court. And our motion is to exclude testimony that the owner of the Chimes department store, Mr. Geller, subsequent to the plaintiff's fall on the stairs, installed a light switch. We won't be disputing that the installation of a light switch was feasible today, and we're moving to exclude it as a subsequent remedial measure.
Any response, plaintiff?
Yes, Your Honor, we do not intend to elicit testimony about that light switch being installed. However, we just did want to be clear that should there be any dispute to the feasibility of such a switch being installed, then the door will have been opened and we will be able to go into the fact that a switch was installed.
Sure, that'll be granted. Approach if you think that the door has been opened for any reason.
Yes, Your Honor.
Anything else?
With that, the defense is ready to begin.
Your Honor, may I just have a brief moment to set up the courtroom?
You may.
May I proceed, Your Honor?
You may.
It's a dark, cold, windy night in January. an employee finishes up their cigarette and heads up the stairs to return to work. They go up those stairs, but when they get to the landing, they try to maneuver around the massive half-open door and they slip. They reach out to steady themselves, but there's nothing there. No guardrail, no handrail, nothing to stop them from falling over the ledge and onto the ground below. Members of the jury, that employee is Jordan Gilmore, and that fall and her subsequent injury are what bring us here today. The defendant, Chimes Department Stores, failed their employees. They failed to provide lighting on those stairs. They failed to provide protective railings, and they failed to provide warnings or training. Their failures, their fault for the consequences. You see, in January of 2019, Jordan was working at the defendant's department store as a cashier. And she's going to tell you today that part of her responsibilities were to go out that back entrance, down those stairs, and throw out trash that came into the business every day. The defendant specifically directed her to do that. The defendant also directed their employees to use that back area to take smoke breaks. So much so that you're going to hear that Jordan used those stairs 20 times in a given work week. Now, because of that direction from the defendant, you're going to learn that meant they had a responsibility to keep those stairs safe. They were the employer, and they were instructing their employees to use those stairs to do their jobs. You'll learn that means that they had certain obligations to keep that area free of unreasonably dangerous risks. And you will learn that they failed. Not once, not twice, but repeatedly. Today, you will hear from Kelly Danes, an expert mechanical engineer. And she's going to walk you through all the ways in which these stairs were obviously dangerous. And then she's also going to discuss the specific regulations that the defendant was required to follow. Particularly, requirements that they provide adequate lighting on those stairs so their employees could see when they went up and down. That they provide guardrails and safety railings on that staircase so their employees had something to hold on to and steady themselves should they fall. And that door, when it opened onto the landing, still allow a certain amount of room so their employees could safely go around it on that platform without risking falling over the edge. Members of the jury, you're going to hear that the defendant failed to fulfill every single one of these requirements. Now, they knew that these stairs were dangerous because in 2010, 9 years before the plaintiff fell, another employee was injured on the same stairs in the same conditions. You're going to see a memo where the defendant's own manager admits they should put lighting on those stairs to prevent similar injuries in the future, and then you're going to see they did nothing. Their failures, their fault for the consequences. And today you'll learn that it was the defendant's failures that caused Jordan Gilmore's injuries. Because on January 23rd, 2013, when she went up those stairs, there was nothing for her to hold on to. When she felt her foot slip, when she began to fall, there was nothing to stop her from going over that edge. When she reached out her hand to steady herself, there was nothing for her to grab onto. So when she went over that edge, there was nothing to stop her from hitting the ground and irreversibly injuring her knee. Members of the jury, today you have the opportunity to hold the defendant accountable for the consequences of their failures. Because employers, they have a responsibility to keep their employees safe while they are at work. So in a few minutes, when defense counsel gets up here and claims that the defendant wasn't responsible for keeping those stairs safe, remember who told their employees to use those stairs every day. It was the defendant. If they try to claim that that platform was a loading dock so there didn't have to be railings on those stairs, ask yourself, Who provided those stairs as the only way to get to the dumpster and the place that they instructed their employees to take their smoke breaks? You'll learn that was also the defendant. And when they blame Jordan Gilmore herself for what happened to her, remember whose responsibility it was to keep the workplace safe for their employees. It was the defendant. Their failures, their fault for the consequences. As such, members of the jury, at the end of this trial, I will come before you again, and I will ask that you return the only verdict that the evidence supports and the justice allows. A verdict putting fault where it rightfully belongs and finding the defendant, Chimes Department Stores, liable. Thank you.
Defense?
May I proceed?
You may.
What happened to the plaintiff was a 1 in 10,000 chance. January 23rd, 2019 was the 10,000th time that the plaintiff walked down that 2-foot staircase at Chimes Department Store. Each of those times before this were the same. There's no guardrail. There's some patches of concrete. There's no outdoor light. And for each of those 10,000 plus times, the plaintiff had no problems. She never fell. She never got hurt. Up and down, day after day, year after year, over the course of a decade. But January 23rd was different. But not because of anything that Chimes Department Store did, but because of something that only the plaintiff could control. You see, as the plaintiff walked back up the stairs to go inside after a smoke break, her friend held the door open, part of the way, blocking part of the platform and blocking part of the light from behind her. Instead of waiting for her friend to go inside, or asking her friend to open the door all the way, or asking her friend to switch over to the other door to open that, plaintiff, who was cold and tired and in a rush to get inside, just decided to try to maneuver around the door onto the tiny piece of platform it wasn't blocking. And that's when she fell. A 1 in 10,000 fall over the decade that she'd worked for Chimes. And the only thing different in those 10,000 times was her own conduct. The plaintiff's failure, the plaintiff's fault for her consequences. Now, despite the low risk of this fall, she filed this lawsuit against her former employer, the Chimes Department Store, claiming that Chimes is responsible for her injuries. I'd like you to meet the owner of Chimes Department Store, Reese Geller. Miss Geller, could you turn your video feed on? Members of the jury, Chimes Department Store has been in the Geller family, well, since Miss Geller was in diapers. It's a family business, started by Grandma and Grandpa Geller, passed on to Miss Geller's parents, and once she reached her 20s, passed down to her. It's a department store right here in Waco filled with odds and ends, household items, and clothing. It serves the people of Waco and employs the people of Waco, including the plaintiff. Now, because the plaintiff filed this lawsuit today, they have the burden of proof. What they have to prove to you today is 3 things. First, that the condition in question posed an unreasonable risk of harm. Second, that Chimes Department Stores knew or reasonably should have known of the danger. And third, that the Chimes Department Stores failed to exercise ordinary care to protect the plaintiff, both by failing to warn the plaintiff and by failing to make the condition reasonably safe. Members of the jury, the plaintiff will not be able to meet their burden today. In fact, they won't ever get past this first element, that the condition posed an unreasonable risk of harm. Now, members of the jury, we're not going to hide from you today the fact that that loading dock, that 2.5-foot staircase out back, it presented some risk. Of course it did. But the question you're answering today is not whether there are risks on going down a stairwell. What you're asked today is whether that risk is unreasonable. And you'll know by the end of this trial that it wasn't. Because numbers don't lie. 10,000 times going up and down those stairs. 1 time falling. It was a 1 in 10,000 trip gone wrong. 99.99% no problems. But the plaintiff acted unreasonably. And unfortunately, it was her choices that led to her downfall that night. You're going to see this photograph today of that stairwell, that 2.5-foot stairwell in the back of Chimes department store. I want you to pay specific attention to those 2 doors, though. Those doors open outwards. You can open one at a time, you can open both. And I want you to pay attention to my cross-examination of the plaintiff herself. She'll explain to you that when she came back up those stairs, her friend popped open the door on the left. What that means is that when the plaintiff was coming back up the stairs, the platform was blocked. We'll even show you a diagram for you so you can see for yourself what a reasonable person would have done in that situation. Members of the jury, today you'll learn that Chimes wasn't even the company in charge of the safety back behind their store. See, Chimes doesn't own the building. They're just renters. They're a tenant of a larger company known as Kermit Realty. Today, you'll see the lease between Chimes department store and Kermit Realty. You'll learn that Chimes is responsible for the safety of the inside of their building. The lease uses a fancy term for that called demised premise. And you'll also learn that Kermit Realty was responsible for the outside of the building, including that loading dock, that stairwell that the plaintiff fell down. That's called the common area. If there was a problem, it wasn't the responsibility of the renters. It was the responsibility of the owner. Because these steps, they weren't built by Chimes. They were never modified by Chimes. They weren't owned by Chimes. It was Kermit Realty who was responsible for them. And members of the jury, that's why we filed what's known as an affirmative defense. Because even if you do find that there was an unreasonable risk of harm, despite the plaintiff having no problem walking up and down those stairs thousands of times before, it wasn't Chimes department store that was responsible for keeping that loading dock safe. It was their landlord. Which is why at the end of today's trial, I'm going to come before you again and ask you to find Chimes family department store not responsible for what the plaintiff did. Thank you.
Plaintiff, call your first witness.
Yes, Your Honor. The plaintiff calls Jordan Gilmore to the stand. Good afternoon. Can you please introduce yourself to the jury?
Hi, I'm Jordan Gilmore.
Ms. Gilmore, I'm sorry, did you want to go on?
Oh, no, we're good.
Okay. Ms. Gilmore, where are you from?
I'm born and raised in Waco, Texas.
And how old are you?
I'm 48.
Are you currently employed?
No, I was injured, so I can't go back to work.
Ms. Gilmore, how were you injured?
I was on January 23rd, 2019, I was taking a smoke break, and when I was walking up the stairs, I lost my, because there wasn't a guardrail, I lost my footing and fell off the back landing and injured my knee, shattered my knee, had to get it replaced.
Now, Ms. Gilmore, we're going to get into all of that today, but before we do, were you at work when this injury occurred?
Yes, I was.
And where was that?
At Chimes department store.
And what was your job working for the defendant?
I was a cashier,
And how long were you a cashier for the defendant?
about 10 years.
So now, Ms. Gilmore, I want to talk about the day you were injured, January 23rd, 2019. What were you doing before you fell?
I um, I I went outside to take a smoke break. It was about 7 o'clock that night, so it was pretty dark.
Now, you say that you went outside. Where specifically did you go?
To the back of the building. That's where we were required to go.
You were required to go there. What does that mean?
Our supervisor instructed us that we needed to go to the back of the building and near the dumpster to take our smoke breaks. We weren't allowed to go in the front, but the only location we could go to was behind down the stairs to right near the dumpster at the back of the building.
Jordan, I'm showing you what's already in evidence as Exhibit 1. What is this?
This is the memorandum, the instruction that we received about where we had to go take our smoke breaks.
And can you read this highlighted portion for the jury?
It says, as you have been told before, if you're going to smoke, you need to smoke out behind the store where our dumpster is. That is the only place you should take smoke breaks on the premises.
Jordan, about how often would you take a smoke break at work?
About once a day.
And other than those smoke breaks, did you ever go into that back area for anything else?
About maybe once or twice a day to take out the trash.
And were you required to take out that trash as part of your job?
Yes, we were. Yes, I was. Yes, we were.
Now, Jordan, I'm showing you what's already in evidence as Exhibit 19. What are we seeing here?
That's the back of the Chimes department store.
That dumpster that we're seeing in this photo, is that the dumpster where you were required to throw out the trash?
Yes, it is.
Now, besides these doors, was there any other way for you to get to that back dumpster?
Not from the back. We would have had to go all the way around the front of the building, but the only way was through those back doors.
I want to focus now on those stairs for a minute. Are there any guardrails on the exposed side of those stairs?
There are not.
What about the side against the wall? Is there a handrail along that wall?
No, there's not.
Was there anything on those stairs for you to hold on to steady yourself?
No.
Was there anything for you to grab onto if you lost your balance?
No.
Now, Jordan, I want to talk about the fall itself. Can you walk us through what you did when you went outside that night?
So it was about 7 o'clock at night. It's in January, so it's at about that time. It's already pretty dark. So I walked down the stairs. One of my coworkers kept the door open so we could see. I walked down the stairs, stood near the dumpster, closer to the dumpster, because they didn't want any smoke getting into the department store. So I was taking the common courtesy and staying away from the store. After I finished taking my smoke break, I started walking up the stairs again. And whenever my friend or my coworker had the door propped open for this light, there was only a small space to get around. I didn't, so as I tried to get around the area, I lost my footing and I knew that I was about to fall. So I had to, in a sense, steady myself as much as I could, but by kind of hopping or jumping, but I landed on the ground. It was really uneven and ended up putting all the weight on my right leg and it's still falling backwards.
Thank you, Ms. Gilmore. I just want to highlight a couple things that you said in there. You said you went outside with a coworker. Who was that?
That is, her name's Riley.
You said that Riley held the door open so you could see. Were there any lights out by that back entrance?
There was a light, but it never worked.
Do you know why it was never on?
We asked our supervisor about it, but apparently the only access to turning on the light is in the store next door.
After you asked your supervisor about that light, did the defendant ever install any warning signs that there were no lights outside?
No,
And to your knowledge, did they ever install any signs like that?
not that I'm aware of.
So you said that after you were done smoking, you went back up the stairs. Jordan, I'm showing you what's already in evidence as Exhibit 3. What are we seeing here?
That's the small area where I had to step around to get back into the building, where I lost my footing and fell.
And is this how the door was open on January 23rd?
Yes,
And when you started to fall, were you at the top of these stairs?
yes, I was.
I'm putting a red circle on Exhibit 3. Jordan, does this accurately depict where your foot was before you started to fall?
It does.
Your Honor, motion to preserve as demonstrative Exhibit 3A.
It'll be so preserved.
Now, Jordan, I want to show you that landing from another angle. I'm showing you what's already in evidence as Exhibit 6. And now I'm going to zoom in. Does this show us that same corner?
It does.
Is this where you stepped before you felt your foot slip?
Yes,
Right next to that hole right there that we see in the cement?
yes.
Now, Jordan, when you started to fall, did you try to steady yourself at all?
I did, but there was nothing to hold on to or grab.
And as a result of your fall, were you injured?
Yes, I was.
How were you injured?
I shattered my right knee, and I landed on the right. Most of my weight landed on the right side, and I ended up shattering my knee, having to get my knee replaced.
Now, Jordan, I want to move on to what happened after you fell. What happened then?
I reported my injury to my supervisor right after I got back in, after Riley helped me back through the door.
And did your supervisor say anything when you reported the accident?
She said, I told her where I fell, and she said, yeah, we probably should have fixed those steps a long time ago. I talked to the other owners a few times, but we always had bigger problems to fix first, I guess. Sorry about that.
You said your supervisor said we should have fixed the stairs. I want to talk about who was responsible for that area where you fell. We're going to go back now to Exhibit 1, that memo. And if we could just enlarge the second sentence of the last paragraph. Can you please read this to the jury, Jordan?
Yes. So if you take a smoke break out by the dumpster, please take some time to clean up the area. Pick up any trash you see and make sure that you dispose of your cigarette butt in a manner that doesn't add to the problem.
Did you ever see anyone from the landlord's office cleaning that area?
No,
Did you ever see anyone who wasn't an employee of the defendant cleaning that area?
no, I did not.
Now let's go to the last sentence of that paragraph. Can you read this for the jury, Jordan?
We want to make sure we keep our area clean and presentable.
And what is the defendant referring to when they say our area here?
The back area of Chime's department store.
The back area that they're calling our area. Is that where you fell?
Yes.
Thank you, Jordan. No further questions at this time, Your Honor.
Cross-examination?
Yes, Your Honor. Good afternoon, Ms. Gilmore.
Good afternoon.
Now, January 23rd, 2019, that wasn't the first time you used those back stairs, was it?
No, it wasn't.
Wasn't the second time either, was it?
No.
I want to take a look at how many times you used those back stairs. Your Honor, permission to create a demonstrative?
You may.
Now, Ms. Gilmore, you told us that your accident occurred on January 23rd, 2019. Is that right?
Yes.
And you worked for Chimes department store for 10 years before your accident.
Yes.
And during those 10 years, you would go outside to the loading dock to smoke cigarettes, right?
Correct.
You'd also go out there daily to take out the trash.
Correct.
In fact, you'd estimate that on average, you were out there about 20 times a week, right?
Give or take, yes.
So if my math is correct, that's about 1,000 times a year, isn't it?
Sure.
And over the 10 years you worked there, that's 10,000 times.
Okay. Yes.
None of those other 10,000 times that you used that staircase did you slip.
Not that I recall.
None of those other times did you hurt yourself.
No.
This accident, that was the first time you ever had a problem using those stairs.
Correct.
Your Honor, permission to mark this demonstrative as Exhibit 1A and preserve for use during trial.
It will be so preserved.
Now, Ms. Gilmore, I'm publishing Exhibit 2. These are the steps that we were just talking about, right?
That's right.
Now, after walking up and down those stairs 10,000 times, it's fair to say you got pretty familiar with them.
Sure. You could say that.
You knew how many steps there were.
Yes.
You knew there wasn't a guardrail.
Yes.
You knew that you could hold onto the wall if you needed support.
Setting my hand on the wall as much as I could. Yes.
You knew that that top platform wasn't very big.
Yes.
And you knew that on the corner of that top platform, the edge was worn down a little bit.
Correct.
You also knew that there were 2 doors leading to inside.
Yes.
One of the doors was on the left, right? Where I just marked with the red rectangle.
That's right.
And the other door was on the right, which I marked with the other red rectangle.
Yes.
Now, these doors, they open outwards, correct?
That's correct.
Now, when you go outside, you could open one door at a time, right?
Correct.
Or you could open both at the same time.
After, I guess so. No. Sure.
So let's talk about what happened the night of your accident. You told us that you walked onto the loading dock around 7 p.m.
Yes.
Now, you knew that it would be dark outside.
Yes.
You even had an iPhone with you at work, right?
I do.
And that iPhone, it had a flashlight on it.
True.
But you didn't bring that out, did you?
No, it was during work hours.
So I'm right, you didn't bring it out?
No.
You also knew that there was another way to provide light for outside, wasn't there?
By opening up the door. Yes.
Right, if you opened up even one of the doors, all the light from inside would project onto the stairs.
Yes.
So you had your friend hold the door open.
My colleague, yes.
I'm sorry, your colleague held the door open for you, right?
Yes.
And as you walked down the stairs, you didn't have any trouble, did you?
I held onto the wall as I walked down the stairs, but yes.
You didn't trip at all?
No.
You didn't fall?
No.
It was the same as those thousands of times before.
Sure.
And when you got to the bottom, you smoked a cigarette.
That's correct.
And after you smoked, you were getting pretty cold.
It's January, yes.
Of course. So being January, you wanted to get back inside.
Yes. And I was done with the smoke break, yeah.
Of course. So you're trying to hurry back up the stairs, weren't you?
Yes.
And in your hurry, you saw your friend holding the door open only part of the way. I'm sorry, your colleague. She was opening the door only part of the way, right?
That's correct.
I want to focus specifically on which door and how your friend was holding that open. I'm publishing Exhibit 5. This is an overhead diagram of what the loading dock looked like, right?
Yes.
On the right, it shows the steps.
Yes.
On the top is the landing.
Yes.
And the landing, that's the area I just marked in green, right?
Yes.
And the area, that's the area you had to step on to get back inside.
Yes.
And this diagram also shows the door that your friend was holding.
Yes.
That's the rectangle I just marked in red.
It is.
And that's how the door was opened when you were walking back up the stairs.
That's correct.
Your friend was holding it part of the way open, right?
That's correct.
Which meant that how she was positioned and how the door was positioned meant that the loading dock was blocked.
Yes.
You only had the space between that red rectangle and the edge of the platform to step onto.
That's right.
That's the area that I just placed the circle on, right?
Yes.
And you saw all this as you walked up the stairs.
Yes. Well, from the light that I could see, yes.
Now, Miss Gilmore, you could have asked your friend to close the door, right?
I could have, but it was windy, and I didn't. It was the only thing that could shed the light.
Well, you also could have had her open the door all the way, right?
I suppose so.
You could have also asked her to just close that door and open the one next door.
Yeah, I suppose so.
If she did that, it wouldn't have blocked your walkway.
True.
These doors, they open outwards, don't they?
They do.
If you let her open that second door, that would give you more space to walk.
That's true.
But you didn't do that either.
No.
Because you were in a rush.
It was cold outside and windy, so we were trying to get back in and finish the rest of our shift.
Right. You were rushing up the stairs to go inside.
Yes.
So you didn't ask her to move.
No.
You decided to just put your one foot on the edge and try to go around the door.
That's correct.
And it wasn't until then that you started to fall.
Correct.
When you started to fall, you jumped off.
Yes.
Nothing further. Pass the witness.
Any redirect?
Yes, Your Honor. Jordan, you were just asked several questions about how often you use those stairs. Why did you use those stairs so often when you were at work?
Oh, because we were told, one, for taking out the trash like we were required with our job, and then two, because that's where we were required to go, excuse me, for our smoke breaks. It was the only area we were allowed to go.
And Jordan, you were just asked about the fact that you jumped off the landing. Why did you do that?
Because I had nothing to grab onto, and I knew I was going to the ground anyways. To at least steady myself, I attempted to instead of falling all the way backwards trying to land, I tried to have some control of what going to the ground, and ended up when I landed putting all the weight on my right side.
Thank you, Jordan. No further questions, Your Honor.
Any recross?
Nothing based on that, Your Honor.
Ms. Gilmore is excused. Plaintiffs, any other witnesses?
Yes, Your Honor. At this time, the plaintiff calls Kelly Danes by deposition pursuant to Federal Rule of Civil Procedure 32.
May I proceed?
Your Honor, before I proceed, we do intend to use two exhibits that have been pre-admitted, and we intend to show them as we read the portions of the testimony in which they are identified. I just wanted to let Your Honor know.
That'll be fine.
Beginning on page 2 of Kelly Danes' deposition, line 6. Good afternoon. Can you please state your name for the record?
Sorry about that, was on mute.
Apologies.
Good afternoon. My name is Kelly Danes.
Moving now to line 12. Tell us about your education.
I have a bachelor's of science in mechanical engineering from the University of Wisconsin-Madison.
Moving now to line 24. I noticed that your CV lists you as a PE. What is that?
It stands for professional engineer.
What do you have to do to become a professional engineer?
Well, you have to graduate from an accredited engineering program, which I did. Then you have to pass the fundamentals of engineering exam, which I did. Then you work as an engineer for 4 years before you take the professional engineering exam. So I took that as well and I passed.
Moving now to page 5, line 14. All right, Kelly, I want to move on and talk about your work in this case. What did you review in coming to your opinions in this case?
I reviewed the deposition of Jordan Gilmore, the deposition of Reese Geller, a number of different regulations from the Occupational Safety and Health Administration, a number of provisions from the International Building Code, and I conducted an inspection of the location of the fall and took pictures of that area.
Moving now to page 6, line 14. Is Exhibit 19 a fair and accurate depiction of how that area looked at the time of Jordan Gilmore's fall?
Yes, well, it was dark when she fell, but other than that, this is the same area and how it looked.
And what does this picture show?
Well, as you can see, there are no railings on the steps up to that landing area, and there is no railing on the landing area itself. Plus, you can see where the railing used to go into the concrete and how the concrete around those areas is worn down and cracked. So you can see that this is a pretty dangerous situation.
Moving now to page 7, line 5. Is Exhibit 22 a fair and accurate description of how this area appeared at the time of your inspection?
Yes.
And what does this picture show?
Well, there are multiple stores in that little strip center, and they all have some kind of landing area and steps behind them, just like Chimes. However, as you can see from these photographs, nobody else has removed the railings from those areas. So what you see in these photographs is what the landing area behind Chimes would have looked like with the railings and what it should have looked like in order to be safe.
Moving now to page 8, line 16. Okay, what opinions have you come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and the landing in question, and the facilities in question must be in compliance with those codes and regulations.
Moving to page 9, line 9. All right, so which portions of the IBC codes and the OSHA regulations did you find important in this case?
First, the general duty clause in the OSHA regulations, which can be found in 29 USCS section 654, and the maintenance provision under section 3401.2 of the IBC.
Why are those significant in this case?
These are general provisions that require an employer and/or party that's responsible for maintaining a building or structure to keep that building or structure in a safe and well-maintained condition, free from recognized hazards. Here, as you can see from the photographs that I took during my inspection of the stairs, the broken off concrete, the lack of stair railings, the lack of railings on the platform, the door blocking the pathway, and the lack of a light switch to turn on the light above those stairs were all hazards that should have been identified with a simple and effective safety program. But the defendant didn't have such a program and never identified or corrected these hazards. So fairly clearly, the defendant violated these requirements under both the IBC and the OSHA regulations.
Moving now to page 11, line 6. What other portions of the IBC codes and the OSHA regulations did you find important in this case?
OSHA 1910.37B1 and IBC 1006.1, which both deal with the lighting.
And why are those significant?
Well, 1910.37B requires that lighting must be adequate and appropriate for a building exit like this one. And 1006.1 requires that any means of egress must be illuminated at all times the building is being occupied. In this case, there was a light above those stairs, but there was no switch for that light inside the Chimes store. So there was no way for employees to turn that light on when they went outside at night. A switch like that should have been installed long before this incident to make sure that employees could see where they were stepping.
Moving to line 24, what's next?
Next, we move to OSHA 1910.23D1 and 1910.24H and IBC 1009.11.
Why are those significant?
All of these provisions require that stairways or flights of stairs must have guardrails or railings on any exposed side. Here, there was no guardrail on those stairs on the exposed side, which is obviously dangerous.
Moving now to page 14, line 22. Anything else?
IBC 1005.2 states that doors opening into the path of egress travel shall not reduce the required width to less than 1/2 during the course of the swing, and that when fully open, the door shall not project more than 7 inches into the required width. When the door is open like it was at the time of the incident, it obstructs the path up or down the stairs to a 1-foot space between the edge of the door and the edge of the platform or the stairs where the plaintiff fell.
Any final thoughts?
Honestly, I just don't know what the defendant was doing here. All of this could have easily been fixed by putting up a guardrail around those stairs and landing and patching the cracked concrete on those steps. It would have been easy. And if the defendant had taken these simple steps, putting a guardrail along those stairs, putting a guardrail around that landing, and making sure it was well lit, and patching the concrete, then the plaintiff's fall would not have happened.
Your Honor, this concludes our read-in portions for Ms. Daines at this time.
Defense, do you have any portions you want to read in at this time?
Yes, Your Honor.
May proceed when ready.
Starting on page 10, line 19. Do the OSHA regulations place any requirements on employees?
Yes, there's a general duty requirement in 29 USCS 654B, which says that employees also have to comply with OSHA standards and regulations and basically have to be responsible for their own actions.
Page 11, line 20. Have you ever seen that light above those stairs turned on at night? Do you know how much light it would have provided?
No, I've never seen that. I just know that it wasn't on and there was no switch for it.
Line 14, page 14, line 12. You would agree, though, that this area was used by Chimes as a loading dock.
Yes, at times.
And a guardrail around that loading dock would certainly inhibit Chimes' ability to use it as a loading dock.
Yes, it would make it difficult.
Can you point to any specific regulations or codes related to how or if employers or others must place guardrails around loading docks?
No, I'm not aware of anything like that.
Nothing further.
Plaintiff, any more witnesses?
No further witnesses, Your Honor. Before we rest, we would just constructively read in the portions of the IBC and the OSHA regulations that Kelly Daines discussed in the portions that we just heard.
Okay, that'll be done constructively.
With that, the plaintiff rests.
Defense, do you have any witnesses to call today?
Yes, Your Honor, we do. But before we do so, we would like to make a motion constructively outside the presence of the jury.
You may.
Your Honor, taking all the evidence in the light most favorable to the non-moving party, which is the plaintiff in today's case, no reasonable jury could find that the service area, the loading dock and the stairs, had an unreasonable risk of harm. What we heard today is that the plaintiff used those stairs 10,000 times. With all the employees in the defendant's company, it was even more. And only one time was she ever injured. This is not an unreasonable risk, Your Honor. Because of that, no reasonable jury could come to the conclusion that this danger was unreasonable.
Response?
Yes, Your Honor. Viewing the light and the evidence in the light most favorable to the plaintiff, we have clearly made a prima facie showing that these stairs were unreasonably dangerous. We've already seen photos today of the condition of those stairs. There was cracked concrete. There was an open hole on the landing right where the plaintiff fell. There were no guardrails. There were no handrails. And as we have heard, there was no exterior light provided for these stairs. Your Honor, all of that together makes it clear that these stairs were unreasonably dangerous. And the simple fact that the plaintiff didn't fall before the day that she actually fell does not mean anything as to whether or not the defendant was obligated to and failed to maintain those stairs in a reasonably safe condition.
Defense, your motion will be denied.
Yes, Your Honor. With that, the defense calls Reese Geller to the stand.
May proceed when ready.
Good afternoon. Please introduce yourself.
My name is Reese Geller.
Where do you live, Miss Geller?
I live in Waco.
How long have you lived in Waco?
I was born and raised in Waco.
Did you go to college?
Yes, I'm a Bear through and through.
I'm assuming you mean you went to Baylor undergrad?
Yes.
Are you currently the owner of Chimes Department Store?
Yes.
Tell us, how did you become the owner?
Well, it's my family's business. My grandparents started it, and I kind of worked my way in the bottom, starting with the buying department right out of college and worked my way up to the top.
What kind of store is Chimes?
It's just a mom and pop's department store. We sell stuff like clothes, shoes, tools. It's not a very expensive store, as we try to just provide for the community.
The community, is that the community of Waco?
Yes.
And in Waco, do you own your building?
No, we rent it.
Who do you rent from?
We rent it from Kermit Realty.
What exactly is your relationship with Kermit Realty?
So Kermit Realty is our landlord and we are their tenant.
What's your understanding of your responsibility for the store as the tenant?
My understanding is that we are only responsible to maintain the part of the property that we lease specifically.
And what is the part of the property that you lease specifically?
It is the inside of the store and part of the parking lot directly in front of the store.
And what makes you say that you're responsible for the inside of the store?
Because it says so in our lease.
I'm going to publish that lease. It's Exhibit 11. Now, you just told us that your family store was responsible for the inside and that Kermit was responsible for the outside of the store. I want to direct your attention to section 1.10 of the lease. What is it called the inside of the store?
It calls it the demise premises.
And demise premises, what exactly does that mean according to the lease?
It says approximately 18,000 square feet of space in the shopping center and being the space crosshatched on the site plan, which shall have a minimum of 100 feet of clear interior width between demising walls along the front of the demise premises.
So that big paragraph you just read, it references cross-hatching on a site plan. I'm publishing that site plan, which is found on the last page of Exhibit 11. Please, can you tell us once it's up? Oh, thank you. Can you tell us what exactly are we looking at here?
So the property we leased is where it says Chimes, and then the area right in front of that says restricted area.
Highlighting what you just referenced, does that green highlight accurately reflect the area that you were just talking about?
Yes.
So that area, that's what you as Chimes are in control of?
Yes.
And what about the area that Kermit Realty is in charge of? Where's that?
It is right behind Chimes, the common area.
I've marked that back area in red. Does that accurately show what, to your understanding, Kermit Realty was in charge of?
Yes.
And in that red area, is that where the loading dock was?
Yes.
Your Honor, permission to mark this as a demonstrative Exhibit 11A for identification purposes?
Any objections?
No objection, Your Honor.
It'll be marked as 11A.
Now, Ms. Geller, despite that loading dock not being part of your responsibility under the lease, did your store still use that area?
Yes.
And why did you use it?
We use it as a loading dock for our store to bring goods in and out of.
And using it as a loading dock to bring goods in and out of your store, as far as you knew, was this permitted under the lease?
Yes.
What did the lease call that?
It called it a common area.
I'm directing your attention to page 9 of the lease, specifically section 6.1. What part of this definition of common area made you believe that the loading dock was a common area and not something that you were responsible for?
It says that the term common area is defined for all purposes of this lease as that part of the shopping center intended for the common use of all tenants, including, among other facilities, private streets and alleys, loading areas, service areas, common utility lines.
Do you know whether the lease mentioned who is in charge of maintaining the common area?
Yes, Kermit Realty was.
I'm directing your attention to section 6.3. What's the title of that subsection?
Maintenance of common area.
What does that say about who is responsible to maintain the common area?
It says that the landlord shall be responsible.
Now, I want to talk about what work was ever done to the stairwell. We've heard today that there is no guardrail. Do you know why not?
There's no guardrail because we requested Kermit Realty remove said guardrail and that we would pay for that change.
Why did you ask them to take down the guardrail?
Because we thought that taking the guardrail down would better allow us to use the property or the area for a loading dock.
Now, why did you ask Kermit Realty to take down the guardrail rather than just take it down yourself?
We were required to under the lease.
Why?
We had to request specifically to them any changes we wanted to be made to the outside of the premises and the common areas.
When you made this request, did Kermit Realty say, no, this is actually your responsibility?
No, they did not.
Did they say by using this as a loading dock, it's now no longer part of the common area?
No, they did not.
Did they ever tell you that it was you and not them who was responsible for the common area?
No, they did not.
Now, I want to republish what's been marked as Exhibit 1A. And I want to talk to you about your employee, Jordan Gilmore. How long did the plaintiff work for you?
About 10 years.
Before this accident, over the course of that decade, are you aware of any other time that the plaintiff slipped on the dock?
No.
Are you aware of any other time the plaintiff tried to move around the open door?
No.
Before what happened on January 23rd, 2019, are you aware of any other time the plaintiff was injured at your store at all?
No.
Thank you, Ms. Geller. I pass the witness.
Cross-examination.
Yes, Your Honor. Good afternoon, Ms. Geller.
Good afternoon.
I want to start by talking about the landing on the back exit of your store. There are no guardrails on that landing, right?
No, there are not.
You had them removed.
Yes.
When you asked to have them removed, the landlord, they didn't say no.
No, they did not.
They didn't say, this is a common space.
No, they did not.
They agreed.
Yes.
They removed the railings.
Yes.
And you reimbursed them for that removal, right?
Yes, we did.
So you paid for it.
Yes.
Now, all the other exits in the strip mall, they have guardrails across their landings, right?
I believe so.
And all those other exits, they have guardrails on the steps leading down from those landings.
Yes.
Now, Ms. Geller, I want to talk about what's in that area by the landing and the stairs. I'm showing you what's already in evidence as Exhibit 19. Ask for the court's patience. I think we might be having a bit of a technical difficulty. Ms. Geller, this is a picture of the landing and the stairs behind your store, right?
Yes.
There are no guardrails on those stairs.
No, they're not.
And guardrails, you'd agree, are meant to protect people from falling.
Yes.
And there's also no handrails on the wall next to those stairs.
No.
Handrails are for people to hold on to steady themselves while they're on the stairs.
Yes.
If someone loses their balance, they can grab onto the handrail and steady themselves.
I suppose.
Well, they can't do that if there's no handrail, right?
Yes.
Now, there's a light outside of this door, correct?
Yes.
I'm adding a red circle to this exhibit. That's where that light is?
Yes.
Your employees, they can't turn that light on.
Yes.
That's a yes that your employees cannot turn it on, Ms. Geller?
Yes, they can turn it on.
Okay. The switch for that light, it's in a different building.
Yes.
Now, you could have asked the landlord to put that light on a timer so it turned on when it got dark, right?
Yes.
If that light was on a timer, it would come on automatically at night.
Yes.
You didn't do that.
No, I did not.
You also could have asked the landlord to install a switch for that light in your building
Yes.
so your employees could turn it on.
Yes.
You didn't do that either.
No, I did not.
Now, I want to talk about how your store uses that landing. Your employees use that area a lot.
Yes.
To your knowledge, only Chime employees use that area.
To my knowledge, yes, that's all that used it, but other people could have used it. I'm just not aware of any.
And to your knowledge, no other stores use that landing for anything at all.
They could have, but I just am not aware of that.
No other stores clean that area that you're aware of.
They could have, but I'm not aware of that.
Now, on direct, you said, according to your lease, that you're only responsible for the demised premises. Is that right?
Yes.
And Ms. Geller, I'm showing you page 13 from your lease, section 7.4. On the third line here, it says the tenant shall store all trash and garbage within the demised premises, correct?
Yes.
And the tenant, that's your department store.
Yes.
And your store stores its garbage in a dumpster by those stairs behind the building, correct?
Yes.
You ordered that dumpster.
Yes.
The landlord didn't order it.
No.
You decided where to put that dumpster.
Yes, because I didn't believe that we were altering the property in any way which we needed to notify our landlord.
That's a yes to my question. You decided where to put that dumpster.
Yes.
The landlord didn't decide that.
Yes.
And you put that dumpster by the back landing
Yes.
for employees to throw away garbage
Yes.
without telling the landlord,
Yes.
without their consent.
Yes.
Because as you said, you didn't believe you were altering their property in any way.
Yes.
Now, you also instruct your employees to take their smoke breaks out by that dumpster, right?
Yes.
And you were here earlier when Ms. Gilmore discussed that memo from your manager, Lane Kim.
Yes.
The memo where your manager referred to that area by the dumpster as our area.
Yes.
Now, Ms. Geller, I want to talk about what you knew about this area. You knew that Jordan wasn't the first employee to fall on those stairs, right?
Yes.
In 2010, another employee tripped on those stairs.
Yes.
Tripped on loose concrete
Yes.
and fell on his face.
Yes.
And you're familiar with the accident report for that accident, right?
Yes, I am.
Ms. Geller, I'm asking you now and directing court and counsel to what's been pre-marked for identification as Exhibit 14. Let me know when you're there, Ms. Geller.
Okay.
You recognize this, right?
Yes.
You've seen it before.
Yes.
This is the incident report for that prior incident.
Yes.
This report is the same or substantially the same as the last time you saw it.
Yes.
It was created by one of your managers.
Yes.
And these are the types of reports that you keep in the regular course of business.
Yes.
Making these accident reports after an accident is a regular practice at your store.
Yes.
Your Honor, pursuant to Federal Rule of Evidence 8036, we offer Exhibit 14 as a business record.
Any objections?
No objection.
Exhibit 14 will be appended.
Ms. Geller, I'm showing you Exhibit 14 on the screen now. And I want to go to the section titled Accident and Loss. It says here at the top, this accident occurred on January 8th, 2010. That's what it says, right, Ms. Geller?
Yes.
At 7:15 p.m.
Yes.
And in this report, the employee says it was dark out.
Yes.
He says the light was off outside.
Yes.
So he went to ask his manager where the light switch was.
Yes.
She told him, just leave the door open and use the light from inside.
Yes.
And then the employee says he slipped.
Yes.
When he slipped and fell, he says there was nothing for him to hold on to.
Yes.
So he couldn't stop his fall.
Yes.
I want to go now to page 2 of this report. In this section, it says, was the accident caused by faulty or malfunctioning equipment, right?
Yes.
The employee responded, the lights weren't on and there were no guardrails, if that's what you mean, right?
Yes.
Now I want to go to the next page, page 3. Here it says, are there any steps that should be taken by Chimes to help prevent such injuries in the future, correct?
Yes.
Your manager provided this response.
Yes.
Your manager wrote, make sure there is adequate lighting on the loading dock, correct?
Yes.
The store never did that, did they?
No.
This was 9 years before Jordan Gilmore's accident.
Yes.
Finally, Ms. Geller, I want to talk about the warnings you provided to your employees about this area. You didn't post any warnings about the drop from the ledge.
No, I did not.
You didn't post any warnings about the lack of guardrails on the stairs.
No, I did not.
Or any warnings about the lack of a handrail.
No, I did not.
Or any warnings about there being no lights outside.
No, I did not.
And any of your employees could use this area, right?
Yes.
Access to the area wasn't limited to authorized employees only.
Yes.
You didn't provide any training to your employees about fall protection, correct?
Correct.
No further questions, Your Honor.
Any redirect?
Yes, Your Honor. Ms. Geller, opposing counsel just asked you about when somebody fell in 2010. I'm going to republish that incident report for you. Or at least I will be, Ms. Geller, one moment. Now, this incident report that occurred in 2010, how many years was that before the plaintiff's accident?
9 years.
In those 9 years, were there any other accidents?
No.
To your knowledge, did anyone else trip on those stairs?
No.
To your knowledge, was anyone else injured using those stairs?
No.
And I want to talk about the injury that occurred in 2010. I want to zoom in on what your employee said. What did your employee say about his injuries when he tripped off that staircase?
He said he wasn't badly hurt.
Nothing further.
Any recross?
No recross, Your Honor.
Okay. May Ms. Geller be excused?
Yes, Your Honor.
Ms. Geller is excused. Defense, do you have any other witnesses?
No further live witnesses, Your Honor, but we will be calling Perry Hayden by deposition.
Okay, you may proceed when ready.
Yes, Your Honor.
Just a moment, Mr. Wick.
And Your Honor, if it's permissible, the same as the plaintiff, as the exhibit is mentioned, we'll be displaying it on the screen.
You may do so.
Thank you, Your Honor. Starting with page 10, line 5. Good afternoon. Can you please state your name for the record?
Good afternoon. Good afternoon. My name is Perry Hayden.
What do you do for a living?
I am a compliance, safety, and health officer with the Occupational Safety and Health Administration.
What does the Occupational Safety and Health Administration, or OSHA, do?
OSHA is a government agency that's responsible for making sure that workplaces are safe for the employees that work there. So we provide information, training, and assistance to employees and employers to try to make workplaces as safe as possible and to make sure that those workplaces are in compliance with OSHA regulations and standards. We are all about employee safety.
And what do you do at OSHA? as a compliance, safety, and health officer?
I am one of the people from OSHA that goes out and inspects workplaces on a regular basis to see if that workplace is in compliance with OSHA standards.
Turning to page 5, line 6. All right, Mr. Hayden, how are you involved into this case?
Well, I conducted an inspection at the Chimes department store in Waco back in 2018, so I assume that's why I'm here.
Mr. Hayden, I'm showing you what has been marked as Exhibit 36. Do you recognize this?
Yes, this is my report from the 2018 inspection of the Chimes department store.
Is Exhibit 36 a true and correct copy of the report regarding your 2018 inspection of the Chimes department store?
Yes, it is.
Why did you inspect the Chimes department store in Waco back in 2018?
It was just a regularly scheduled inspection. We do that all the time, just show up and do an inspection.
So were there any complaints that led to this inspection?
Not that I'm aware of. I went out there because it had been a while since we had been there. That's it.
Page 6, line 8. Did you issue any citations to Chimes as a result of your inspection back in 2018?
No, I did not.
Did you inspect the area behind the store where there's a little landing and some steps?
Yes, I did.
Page 8, line 20. Is there any OSHA regulation that does specifically discuss loading docks?
Yes, 1910.28B13 clearly states that guardrails aren't required on loading docks because they aren't feasible. You can't very well load something onto the dock with a bar.
Your Honor, pursuant to Federal Rule of Evidence 106, if defense counsel is going to read in this portion, we ask that they read in the entirety of the regulation. As an offer of proof, Your Honor, this regulation states that if this regulation applies, that access to that platform must be limited to authorized employees and that fall protection training must be provided.
Your Honor, may I respond?
You may.
If opposing counsel wants to read more of the deposition in on cross-examination, they may. We're reading the exact words of the deposition that we provided them pre-trial.
Your Honor, that's exactly my point. In the deposition, Hayden Perry does not accurately state the statute that he's talking about in completeness. Therefore, the rule of completeness requires that if we're going to bring in this testimony, that the jury be presented with the entirety of the regulation so they can actually understand everything that it says.
Is that statement in the deposition that they're reading from currently?
The full statement of the regulation is not, Your Honor. The expert does not fully cite and correctly cite the regulation.
I'll permit you to read that in when you're given the opportunity to read the deposition.
Yes, Your Honor.
Defense, you may proceed.
I'll ask the question again. Is there any OSHA regulation that does specifically discuss loading docks?
Yes, 1910.28B13 clearly states that guardrails aren't required on loading docks because they aren't feasible. You can't very well load something onto the dock with a bar in your way.
Nothing further.
Cross?
Yes, Your Honor, before we begin, we'd like to constructively read in that statute, 1910.28, and show it to the jury.
It's been constructively read in and provided to the jury.
Section 1910.20. Oh, I apologize, Your Honor. Section 1910.28, duty to have fall protection and falling object protection. Subsection 1, unprotected sides and edges. When the employer can demonstrate that the use of fall protection systems is not feasible on the working side of a platform used as a loading rack, loading dock, or teaming platform, the work may be done without a fall protection system, provided A, the work operation for which fall protection is infeasible is in process, B, access to the platform is limited to authorized employees, and C, the authorized employees are trained in accordance with Section 1910.30. Moving now to the deposition of Perry Hayden, beginning on page 6, line 11. Did you inspect the area behind the store where there's a little landing and some steps?
Yes, I did.
Moving now to line 22. When you went out there, what did you notice about the steps in that landing area?
Well, at first I was a bit alarmed because there were some pretty obvious issues.
Like what?
Well, there were stairs and a landing area, but there were no guardrails anywhere. Plus, the concrete on the edges of those steps and that landing were cracked and eroding away. Someone with half as much experience as me could look at that and see some pretty obvious problems.
Moving now to page 9, line 23. Ms. Hayden, I'm showing you what's been marked been marked as Exhibit 38. Do you recognize this?
Yes, this is an email that I received from one of my superiors in May 2019.
Moving now to line 5. Do you disagree with the assessment of your boss in this email?
No, I don't.
Your Honor, at this time, we offer Exhibit 38 into evidence and ask to be able to publish it to the jury.
Any objections?
Yes, Your Honor, we'd object to hearsay.
Your Honor, yes, Your Honor, this is not hearsay. This is an adopted admission. As we just heard, Perry Hayden was asked if he disagreed with the assessment of Perry Hayden's own work that his boss provides in this email, and he specifically says, no, I don't. As such, this is an adopted admission and is not hearsay.
Any response, defense?
Your Honor, this is still hearsay. It's an out-of-court statement being used for the truth of the matter asserted. This isn't a party opponent. This doesn't meet any exception. This is an email from someone's supervisor about a performance review. This isn't something adopted by the speaker. And even if it was, that doesn't mean an exception for hearsay. This is not a party opponent admission. This is just an expert admission.
Any response from the plaintiff?
Yes, Your Honor, the very definition of an adopted admission means that it's an exception to hearsay. Perry Hayden is saying that she doesn't disagree with what this says, therefore she is adopting it as her own, and that cures the hearsay objection. Furthermore, Your Honor, under Rule 807, because Perry Hayden doesn't agree with it, there are no issues with the reliability, and this email is the most probative piece of evidence that we have to the point that it proves, which is as an offer of proof that Perry Hayden has a tendency to not issue citations when she conducts reviews of work sites.
Your Honor, may I briefly respond?
That objection is overruled. You may proceed.
Publishing Exhibit 38 to the jury. And beginning at the end of the second line, in the course of reviewing your work, I noticed that you continue to issue very few citations when out inspecting workplaces. In fact, I compared your numbers with the others in the Central Texas region, and you have issued the fewest citations of any inspector we have on staff. In fact, over the past 5 years, you have issued less than half as many citations as the next closest inspector. This is a problem. Returning now to the deposition of Perry Hayden, page 11, line 18. Did you notice a light out there when you were doing your inspection?
I did. You'll see it noted in my report.
Did you ask the manager about that light?
I did, like you can see in my report.
What did the manager say?
The manager told me that they always turn the light on when somebody goes out back at night. So that seemed good enough for me.
Did you have them turn it on for you while you were there?
No, didn't seem necessary.
Your Honor, this concludes our read-in portions for Perry Hayden.
Any redirect from the defense?
No, Your Honor.
Any other witnesses from the defense?
No, Your Honor. The defense rests, and we renew our mid-trial motion for judgment as a matter of law. Even taking all the evidence, I'm sorry, Your Honor, I assume this is constructively outside the presence of the jury.
You may.
Even taking all the evidence in the light most favorable to the plaintiff, no reasonable jury could find that there was an unreasonable risk of harm on this loading dock. We heard from the plaintiff today that she went up and down these stairs thousands of times. We heard from the defendant today that this loading dock was in the same condition for 10 years. And although opposing counsel pointed out that one other person fell off this loading dock, they weren't badly injured. And this is over the course of a decade. Only 1 or 2 injuries out of thousands of times, thousands of employee trips up and down those stairs. Additionally, Your Honor, we heard from an expert witness today that they visited the site and an OSHA regulator, and they didn't issue any citations. Therefore, no reasonable jury could find that this had an unreasonable risk of harm to Jordan Gilmore.
Plaintiff, any response?
Yes, Your Honor. We've clearly proven by a preponderance of the evidence, taking that evidence in the light most favorable to the non-moving party, that these stairs were obviously and unreasonably dangerous. Once again, we've seen repeated pictures of crumbling concrete, of a lack of any safety features whatsoever, of a literal hole in the landing where the plaintiff fell. And we've heard testimony time and time again that there was no light out there, and it was dark, and it was hard for the plaintiff to see. Your Honor, the defense is claiming that because of some statistic, that means that this wasn't unreasonably dangerous, but that statistic, it doesn't matter. It only takes one fall. It only takes one injury. If that injury was a result of the obviously dangerous circumstances that we have outlined today, then we have proven our case.
Defense, your motion will be denied.
Yes, Your Honor.
Anything else to take up?
No, Your Honor. But may we get a time check?
You may. Let's just do one thing real quick here. Plaintiff, any rebuttal witnesses?
No, Your Honor.
Okay. Do you rest in close?
We do, Your Honor.
Time check. Looks like the plaintiff's at 16:25 and the defense is at 24:59. And before we start closing, let's take a 5-minute break.
Yes, Your Honor.
So see y'all back at 26. Both parties ready to proceed into closing?
The defense is as well, Your Honor.
All right. Plaintiff, you may proceed when ready.
Their failures, their fault for the consequences. The defendant failed to keep their back staircase reasonably safe. They failed to provide adequate lighting. They failed to provide safety railings. They failed to provide any warnings or trainings, and they failed to ensure that that door, when open, still left their employees enough space to safely get around. Failure after failure after failure means that on January 23rd, 2019, when Jordan Gilmore fell off the edge of that platform, they were responsible for the consequences. Members of the jury, let's talk about all those failures. Starting with the defendant's failure to take responsibility for those stairs. Now, soon the judge is going to instruct you, and they're going to instruct you that you have to determine that the defendant controlled those stairs. And that control can be proved by a contract, but it can also be proved by actual control, what the defendant said and what they did. Now, they can point at the lease all they want, but members of the jury, it doesn't matter. Not when their own words and their own actions show that they specifically intended to control that landing and those stairs. You saw the defendant's memo to their employees. It tells their employees to use those stairs. It tells them to clean up that area. It tells them that that's where they're supposed to take their smoke breaks. And most importantly, it calls that area our area, not the landlord's area, not a common area, our area. Members of the jury, that makes sense because that's where the defendant put their dumpster. The dumpster where they keep their trash, the dumpster where, according to their lease, wherever they put their trash is part of the demised premises, the very property that that lease covers. By putting that dumpster there, they were exercising further control. They were saying, this is our space. But now they want to come here today and not be held responsible for that space. You even heard from the defendant herself, Reese Geller. She had to admit nobody else uses that space that she knows of. Nobody cleans it. No one else accepts deliveries there. It's just her employees and her deliveries. And it was her employees that walked the OSHA investigator, Perry Hayden, through his investigation when he visited the site in 2018. It wasn't anybody from the landlord. It wasn't anybody from another business. It was her employees. They were the only ones who used that space. The defendant exercised actual control, so they were responsible for keeping that area reasonably safe. Because members of the jury, according to the regulations that you heard today, an employee is responsible to their employees to keep the workspace safe from unreasonably dangerous risks of harm. And the pictures you saw today of those stairs, they make it abundantly clear. This was an unreasonably dangerous staircase. Members of the jury, look at these pictures. I apologize, Your Honor. It seems we're having a bit of a technical difficulty, but if you recall, members of the jury, you saw Exhibit 3 and Exhibit 6. You saw the pictures of the cracked concrete that we're seeing here on the screen now. You can see the hole on the edge of that stair. You can see that there is no railing. You don't need to be an expert. Your own common sense shows you just looking at this that it's not safe. And then their expert agreed when he went to the site to perform his inspection, these were obvious problems. Now they tried to tiptoe around that by saying that this was a loading dock, but members of the jury, you heard that the defendant told their employees to use it all the time. They told them to use it to take their smoke breaks, to take out the trash. And if this was a loading dock, members of the jury, then they had to restrict access to that area to authorized employees, and they had to provide adequate fall protection training. You heard when I asked the defendant on cross-examination, they did neither of those things. Their failures, their fault for the consequences. Additionally, members of the jury, there were specific statutory requirements that the defendant had to fulfill to keep this area safe. You heard about requirements that there be adequate lighting on those stairs. You heard that there was none. The only light that reached that area came from inside the store, but OSHA regulations specifically require that places of egress be adequately lit. And the defendant, they knew this was a problem because you heard about that previous accident. Another employee on those same stairs in January in the dark tripped and fell. And what was defense counsel's response? Well, he wasn't badly hurt. So they're saying that one of their employees was hurt on their property, and their response was, well, not good enough of an injury to warrant us doing anything about it. Not good enough of a reason for us to actually fulfill our obligations and keep you safe at work. Try again next time. That's not acceptable, members of the jury. They had a responsibility to provide lighting out there, and they failed. And when they became aware that it was an issue, when their own employee filled out an accident report and said, we should provide adequate lighting out there to make sure this doesn't happen again, they didn't do that. They just waited until the next time somebody got hurt, and on January 23rd, 2019, that happened. So they cannot now come here and say they weren't responsible for lighting that area in the first place. Now they're going to get up here and they're going to point to the fact that Perry Hayden didn't issue any citations when he investigated. But remember, Perry Hayden asked about that light, and what was he told? He was told that it turns on. And first of all, he didn't check that for himself. But second of all, members of the jury, you know that's not true because the defendant couldn't turn that light on. Jordan Gilmore asked about that light, and they were told, well, there's nothing that we can do about that. So the fact that no citations were issued, well, that's based on false information that was provided to that OSHA investigator. The defendant knew the lighting was a problem, and not only did they do nothing to fix it, but they intentionally covered it up when asked about it by a federal officer. All they had to do was install an automatic light or ask the landlord to put a switch in. Then none of this would have happened. They failed to do so, so the consequences are their fault. Members of the jury, additionally, the defendant had specific obligations to put protective railings on those stairs. Now, you saw this picture today. And this is what the defendant should have done. Had a protective railing on the outside of those stairs, so as their employees went up and down, they could hold on to it. And in the event that they fell, something would be there to protect them. And this was specifically required by the Occupational Safety and Health Administration regulations. And not only did the defendant not do this, but they removed the railings that were already there. And they claim that this was a loading dock, but members of the jury, you heard how many different ways that this area was used. If that many different people were going to use it in that many different ways, then the defendant had a responsibility to keep all of those people reasonably safe. And furthermore, members of the jury, even if this was a loading dock, stairs are not part of a dock. Stairs have their own requirements, specific obligations that they have safety railings so people can be safe when they go up and down. And if there had been a railing there on January 23rd, 2019, Jordan Gilmore would have had something to grab onto. She would have had something to steady herself. She would have had something to keep herself from falling. Because of the defendant's failures, there was no railing. So the consequences are their fault. And then, members of the jury, knowing about all of these obvious issues, the defendant didn't even do so much as warn their employees. They had an obligation to warn their employees about risks, but you heard they posted no signs, no notices, no indications that there was broken concrete, or no lights, or no railings, nothing. They just sent their employees out there, sometimes in the dark, on their own. And installing those notices, it would have been easy. It would have taken seconds, if that. But that's what you get from a company who doesn't care about the safety of their employees. From a company who, when one of their employees is injured, says, well, you weren't injured that badly, so we're not going to do anything about it. They failed to protect their employees, so they are at fault for the consequences. Members of the jury, the consequences were that on January 23rd, 2019, as Jordan Gilmore climbed those steps and moved around that half-open door, her foot slipped. The broken concrete and the hole in the ground make it clear what caused her foot to slip. And as she began to fall, Well, there was no railing there to catch her. As she reached out her hand to try and steady herself, she met only open air because there was no safety railing for her to steady herself. So she fell over the edge and onto the ground and suffered a life-altering knee injury. Today, the defense would have you believe that that injury is Jordan's fault. But members of the jury, just because somebody goes up a set of stairs 10,000 times without an injury doesn't mean that it's their fault when they slip and fall. And that does not mean that these stairs were not unreasonably dangerous. Members of the jury, the exact reason that safety measures are required at work is for that 1 in 10,000 time. It's for the one time that your employee missteps or slips or trips. That's why guardrails are required. Does defense honestly want you to believe that it's the obligation of an employee to navigate what can only be called, members of the jury, a death trap? We know that Jordan Gilmore didn't die, but we don't have a better word because they provided crumbling stairs with holes with no railings and absolutely no light. And they'd have you to believe that it's on the employee to keep themselves safe, that it's on the employee to bring their iPhone outside because they can't be bothered to provide a light. Members of the jury, they cannot be serious. That's the only defense that they could think to bring you here today, but it is unacceptable. They were the employee. It was their job to keep that area safe, and it does not matter that this was the first time in 10 years that Jordan Gilmore fell off those stairs, because safety measures, they're for the one time. They're supposed to be there to catch you the one time that you fall. The fact that they were not there, this doesn't make Jordan Gilmore's injuries her fault. It means that by some stroke of luck, the defendant only had 2 employees injured in 9 years. The fact that nobody else was injured, that doesn't mean anything. Because when someone did trip, when someone did fall, when someone did need a safety measure to be there, they were nowhere to be found. And that's because of the defendant's failures. Do not let them distract you and tell you anything else. Members of the jury, it was the defendant's responsibility to keep these stairs safe. Employers have responsibilities to their employees. That is how people are kept reasonably safe at work, and that is why these regulations and these obligations exist. They failed time and time again to fulfill their obligations, to make sure that area was not unreasonably dangerous, to provide adequate lighting, to provide safety railings, to provide warnings, and to provide training. They didn't do any of it. That is why Jordan Gilmore was hurt. Hold them responsible for their failures. When you get to question 1 on the jury sheet about whose negligence caused Jordan Gilmore's injuries, you can confidently answer yes for Chimes Department Store and no for Jordan Gilmore. And when you get to question 2, you can hold the defendant fully liable. Thank you.
Defense, you can proceed when ready.
1 in 10,000. Those were the odds of the plaintiff getting injured by walking up and down those stairs to take her smoke break. Odds so low that no one would ever take those stakes in Vegas or bet that on sports. Members of the jury, those numbers told the Chimes Department Store that their loading dock was safe. Those numbers tell you there was no unreasonable risk of danger to Jordan Gilmore, especially when you look at why this 1 in 10,000 times was different. It wasn't because of anything that the Geller family did or didn't do. It was the plaintiff's conduct herself. Her failure, her fault for the consequences. Now, members of the jury, I want to make sure that you remember when you go back into the deliberation room today, that the plaintiff has the burden of proof to prove that Chime's department store was dangerous. What that means is that they had to get up here today and convince you, each and every one of you, of three things. First, that the condition of the loading dock area posed an unreasonable risk. Second, that they knew or reasonably should have known of the danger. And third, that they failed to use ordinary care to protect Jordan Gilmore from the danger. Now, I want to focus on that first element, the one that the plaintiff failed to prove above everything else, and the one that makes this case fairly simple for you, whether the condition in question posed an unreasonable risk of harm. Because members of the jury, it's not enough for the plaintiff to just show, well, there was a possible risk of harm. It had to be an unreasonable risk. Now, the plaintiff has tried to claim today that this loading dock that you saw was dangerous. Members of the jury, your job here today means that you don't just assume it must have been unreasonably dangerous because the plaintiff was injured. The plaintiff had to prove that the risk of those injuries was unreasonable to begin with. I said to you in my opening statement, and I'll say it again to you now, we're not hiding from the fact that there was a risk on those stairs. But the issue for you is not whether there was a risk, because everything in life has one. You have to evaluate if it was unreasonable. And the plaintiff's own testimony tells you that it wasn't. You see, the plaintiff has been working for Chime's department store for 10 years. During those 10 years, she went to the loading dock 20 times a week. That's 1,000 times a year. Over the whole decade that she was there, 10,000 times. And not once did she ever fall off the loading dock. Not once did she slip. I asked her today if she ever had any problems getting on that loading dock, walking up and down those stairs before. Do you remember her answer? No. The plaintiff wants you to believe today that those numbers don't matter. That doesn't matter how many tens or hundreds of thousands of trips have been made up and down those 2.5-foot stairs without incident. Members of the jury, that's exactly how we determine safety. If the plaintiff herself successfully went up and down those stairs thousands of times without any harm, how could it possibly have been an unreasonable risk? How could you possibly find Chimes responsible based on odds so low? You can't, members of the jury, because that would be unreasonable. Now, members of the jury, how this negligence charge works is that because the plaintiff failed to prove that first issue, you don't even need to go further with the verdict form. But for argument's sake, let's talk about that second issue, whether Chimes knew or reasonably should have known of the danger. Now, the plaintiff, again, wants you to focus on one other fall. That occurred 9 years before the plaintiff fell down the stairs. They want you to believe, well, because someone else fell at some point, that Chimes knew or reasonably should have known of a serious danger. The plaintiff just got up here and tried to condemn the Geller family for not rebuilding the stairs after someone fell. But members of the jury, if you think reasonably, well, why would they? You heard about what happened. Someone fell off this 2.5-foot staircase. They didn't really get hurt. They said so themselves. They walked it off. This wouldn't sound off alarm bells to anyone that this was some kind of death trap. Now, members of the jury, there's something else I need to point out. I told you in my opening statement to pay attention to the plaintiff's choices in this case. I'm going to ask you to remember those again. Choices to rush. Choices that sadly contributed to her own fall. You heard the plaintiff on the stand today admit to you that when she was done smoking her cigarette, she started coming back up the stairs. She was fine at first. She was holding onto the wall, no issue. Now, when she reached the top, she saw her colleague holding the door open. She saw that she had a choice. She could ask her friend to shut the one door and open the other to give her more space. She could go down the stairs and just wait a second so that her friend could open the door entirely to widen the space for her to set up. But the plaintiff chose not to do that. And why not? Well, you heard me cross-examine her today. She had to admit to you she was in a hurry. She was in a rush. She didn't want to wait for a safe opportunity. You saw that small black circle. That was the only available space on that platform for the plaintiff to step onto. And instead of just saying, okay, I'm going to wait a second, she just tried to snake her way around that door, Spider-Man onto the platform, even though the door was blocking her path. A door that was obvious to her, a risk that was obvious to her, something that she could have avoided, but chose not to. Ladies and gentlemen, that brings me to the third and final element that the plaintiff had the burden to prove to you today. That Chimes failed to exercise ordinary care by both failing to warn the plaintiff of the condition and failing to make it reasonably safe. Well, we know that Ms. Gilmore needed no warning for a condition that she knew about for 10 years. She told us today that she knew about those worn down edges the whole time that she worked there. So let's focus on whether or not Chimes failed to make that condition safe. You met Reese Geller today, the owner of the family department store, who said she's been part of this basically since she was in diapers. She's dedicated her life to providing our community with affordable goods and job opportunities. Now, Ms. Geller and Chimes, they had reason to believe that the loading dock was safe. Not only just because there really weren't very many injuries, but also because an OSHA inspector told them that. Now, you didn't get to meet Perry Hayden, the OSHA inspector, live today, but you did get to hear Mr. Hayden's testimony during deposition. And you got to take a look at this OSHA report. When you go into the deliberation room, you're going to get to look at that closer. You're going to see that Perry Hayden went to the Chimes department store just 6 months before the fall and did an inspection. Keep in mind, Mr. Hayden is an independent agent from the U.S. Department of Labor. He wrote this report. And he said that he didn't identify any potential workplace hazards inside the store. Even after going to the loading dock where the plaintiff fell, walking down those same stairs that the plaintiff fell, gave no safety violation citations to Chimes. Besides, members of the jury, if anyone should have changed the condition of that loading dock, it wasn't even Chimes to change. Chimes was just a tenant. Ms. Geller explained that to you today. Her family owned the store, but they didn't own the property. They rented the store from Kermit Realty Company. You saw the lease today. You saw the diagram of what Chimes was in control of and what they rented, and more importantly, did not rent as tenants. The loading dock in the back, that area in red, was called a common area under the lease. What that meant was that Kermit Realty and not Chimes was responsible for the area. And members of the jury, that area in red is where the loading dock is. That's why when they removed those guardrails, it was Kermit Realty Company who did it, and not Chimes. And that's why when you're asked whether the negligence, if any, of those named parties below proximately caused the injury, you can confidently answer no for Chimes department stores, and yes for Kermit Realty Group and Jordan Gilmore. Members of the jury, this is my last opportunity to speak with you. Because the plaintiff has the burden to prove their negligence case to you today, after I'm done speaking, they have one more chance to try to persuade you. Make sure that they answer the difficult questions in today's case that remain unanswered. Make them explain how that loading dock was really such an unreasonable risk. And Miss Gilmore herself went up and down that stairwell 10,000 times without a single issue. Make them explain why Chimes should be held responsible. The plaintiff could have just had her friend open the door. These answers and explanations come, if they come at all. They don't persuade you. Tell the plaintiff that. Because although they get to speak to you last, you members of the jury get the last word. Or in this case, in this courtroom, the last 2 words. Find Chimes department store not responsible. Thank you.
Plaintiff rebuttals?
Yes, Your Honor. Members of the jury, the defendant is gamble with their employees' safety. Because if a person gets hurt once every couple of years, well, then that's not enough to warrant installing some railings and a light. Their failure to do those things that they were required by law to do is what made this staircase unreasonably dangerous. You have those pictures. You can look at the broken concrete and the lack of lighting and the lack of railings for yourself and see that this is clearly unreasonably dangerous. Members of the jury, the defendant is content to be callous with their obligations and try to blame their employees when they are injured at work because they're not willing to accept the responsibility that they bear as an employer. But the truth, members of the jury, is that Jordan Gilmore was an employee on their property doing work that they directed her to do when she fell. And when she fell, there was nothing there to catch her fall because the defendant didn't put it there. They can give you every statistic that they want, but the truth is, members of the jury, even if there's only a 1 in 10,000 chance that someone falls, that is why safety requirements and regulations exist. So that for that one time, when that employee slips, they have something to grab onto. And if they don't, then you are on the hook for not providing it to them. Do not let them distract you from their responsibility to their employees. Do not let them distract you from the fact that they were the ones who had to put those railings and that light and those warnings and that training in, and they are the ones who failed over and over and over again. Hold them accountable for the consequences of their failures. Find the defendant, Chimes department stores, liable. Thank you.
Okay, we're going to take a few minutes to tally up these ballots. And then once we're done there, we'll come back and have some brief feedback for y'all. All right, we're good to go. Does anybody want to give feedback?
Sure, I'll go real quick just to get it out of the way. Can everybody hear me? We're good. Hi, I'm Steven Lopez. Competed a bunch, coached a bit, and have judged a lot of tournaments. Just want to say congratulations to you both on making the tournament. You're both excellent advocates, and you must be exhausted now after the last 2 days. So congrats. I'm just going to be super quick. I don't have a lot of substantive stuff. I thought the round was super clean. And there just wasn't a lot of huge areas or room for improvement. It was a really close round. I'll just say, Miss McGugan and really both of you kind of lit up in closing, right? There was a lot of passion, a lot of fire there in closing, and especially for you, Miss McGugan, I wish I would have seen a little bit more of that maybe on cross. I think you both, when you get in teams, right, especially when you're paired up with somebody, it's usually somebody who's like the super loud one, and then somebody who's like the reasonable, methodical one, right, who just goes and prosecutes their case. And I think both of you are kind of like the methodical ones if you're on a pairing, right? So it's good. I mean, it's just a super clean round, but I really like what I saw in the close for both of you, and I would have liked a little bit more of that in crosses, but really, I have no real critiques. Miss Doig, the one thing I would say for you is, you're demonstrative. I get you want to make it demonstrative. We're on Zoom, things are boring. You want to make something happen. But for me, it didn't really, it didn't show me anything new. You had said 10,000 steps about 100 times by the time we got to your demonstrative. And then you just put it up there and we're like, yes, it adds up to 10,000. We get it. It didn't really move the ball for me, and you kept coming back to it. I mean, I understand the urge to want to do a demonstrative, but make sure that you're illuminating a new point or showing something in an interesting way. For me, it just didn't really do much for it, but I applaud the effort at trying to do something right to break up a Zoom trial and to make it a little less dull. Other than that, fantastic round. Congratulations.
I'll go next if that's okay. I'm Holly Naritz. It was actually really entertaining to watch this, and I appreciate having the opportunity to judge you. And I, again, congratulate you, just like Stephen did, on making it this far and doing such a great job. I agree, you both did very, very well. Don't have much in the way of criticism. On the plaintiff's side, I thought that you had really good pacing and good structure, particularly in your opening and closings. And then I guess a couple of comments that I had, very minor issues in your closing. I think calling that staircase a death trap personally is a bit of a stretch. And I think you sort of acknowledged that when you used the phrase, but I don't know that I necessarily like that characterization of it. And then I was left wondering, when you were discussing the jury charge, how you wanted the jury to address Kermit Realty, because you sort of just glossed over them. I'm assuming you want them to say, no, they weren't negligent, but that was sort of just a hanging chad left there unanswered. Wasn't quite sure where you wanted the jury to go with that. On the defense side, I liked that you adopted the phrase in your opening and your closing that the plaintiffs had been using, their failures, their fault for the consequences. You sort of turned that around on them and applied it to the plaintiff herself, which I thought was a great move. And then I thought you did a great job on cross, getting the plaintiff to admit that she was in a hurry, she was in a rush, and that she jumped off the platform. I thought that was very well done. And then the one thing I was left wondering on your side, again, this is probably just a minor factual issue. It might be something that's not answered in the problem packet. I don't know, I haven't read the packet. But I was just left wondering, whenever you were addressing the incident report for the prior fall down the stairs that happened 9 years before,
I didn't really have an answer for why the light was not corrected, other than I guess it was Kermit's responsibility, but I feel like you could have, assuming the facts are there, they might be absent. But if they are there, I feel like there could have been a little bit more addressed there about what the department store could have done about the light, you know, if they had asked Kermit to correct it, that sort of thing. But other than that, I think you both did an excellent job. Again, congratulations and good luck to both of you.
I'll go ahead. I agree. You both did very well. I hate saying this, but you were head and shoulders over the round I watched yesterday. I was very impressed, and just to be here is impressive, but you both did a really good job. No substantive comments. I don't think jurors really care anyways. I think they're style over substance anyways. And I've learned that practicing law. One thing I will say for you is that I think when you get in the real practice of law, I think you'll find that this is actually not all that different. You'll find yourself be very prepared. And I think it's a good thing that you're doing to do these tournaments and to participate. And I think you'll get to actual trials one day and find your head and shoulders over your competition there. So you've done a really good job. Impressed with both of you. The only thing I will say as far as like maybe something that I would change, take it for what it's worth, is nothing. I won't even buy you a cup of coffee, but I don't know how to describe it, but whenever you watch the news, these reporters, they have like this reporter talk and this reporter speak, and they say things and they have like this cadence to their voice. Trial lawyers and people in mock trial do the same thing. They start to sound a certain way, and they start to say some things when they're communicating with the court or the jury. Try to avoid that. Try to just think about what you're saying, be present in the moment, try to communicate with the jurors. I know it's hard on Zoom, but I just wrote down some notes of some of the things that I heard, and you, both of you did this, so I'm not saying one or the other, but starting sentences with "in today" or "now" and "see." I bet you if we went to the transcript, we'd have 100 of each one of those words. When you're transitioning questions, or especially in open and close, using those things, or even something odd like when you're talking to the judge, like, "If it's permissible, Your Honor, I'd like to do this." I would say just try to speak a little more casually and find yourself a little more comfortable in your content and what you're saying. It may just come off a little smoother and a little easier as you're transitioning through questions and you're not kind of repeating yourself these starters. So, but I can tell you, you're head and shoulders over who I've seen recently, and so much better than I ever was back when I did this in law school. So best of luck in the rest of the tournament. I think you guys are doing a great job.
All right, and I'll be pretty brief. With you, Miss McGugan. Am I pronouncing your name right? Close
McGuigan.
enough?
That's
McGuigan.
okay.
Thank you. I figured I had that wrong. I had my thick Texas accent, so it's a little bit hard for me to say that. So I will say for you, I thought you were superb in closing, and I would have liked to have seen just a little bit of that passion in opening. You can't do as much in opening statements as you can in closing arguments, but just a little bit more in opening statements. And then the other thing that I would make, this is the first time that I've heard the whole lease argument, who's responsible for what, and the fact that there was a request, you know, that the guardrail be taken off. I probably in closing argument would add an argument if it's permissible along the lines of, if they can request that the guardrail be taken down and pay for it, why can't they do that with lighting? Why can't they request additional lighting, something along those lines? But technically, I thought your examinations were great. I thought your cross-examination was great, and you did a good job. Miss Doig, you were superb. You did a great job too. I might focus a little bit on what was different on this one day out of those 10,000 days, which would be that door, right? So I might focus on that a little bit. I thought you were, in terms of cadence and you know, how you were handling things, moving, slowing down, you know, using different tones of voice. I thought you did that well. And I thought your examinations were really good. So you guys, both of you, made this very difficult on us because you both really just did a superb job. So good luck in the upcoming rounds.
Y'all were fantastic. Really enjoyed watching y'all. I'm going to go just a little bit more off of what Scott said and just talk to y'all about being comfortable using your own words. Because when you start talking like yourself in front of a jury, you seem more yourself, more earnest, more honest, more trustworthy. So y'all all had a tendency to put members of the jury just randomly in throughout your arguments. I would look at it as if you were telling a story. You wouldn't be like, and such Carolyn, and then such happened, and then later on, Carolyn, such happened. Like, think about it saying maybe once. Like I go through openings and closings, and sometimes I never say it. You're looking at the jury. You're doing enough right there. You're engaged with them. Focus on that. And then only other big thing would be thanking the jury after you finish closing. They haven't done anything for you yet. They may come back and just hose your dude. And then you're like, oh, I'm really sorry. I thanked him now. You're not going to end on such like a punchy point if you thank him at the end. It's kind of like ending here and then having to drop off. Find the point you want to end on it. Oh, sorry, Scott. End on it.
I'll let you done.
No worries. And move on.
The one thing I thought about just now when you said that, Carolyn, when the opposing lawyer for your rebuttal puts up a question on the tee, I know you came in substantively and did address it, but like I said, these jurors are style over substance. You got to come in and be like, you know what? She put this question out there, and I'm going to answer it. Here it is, and let that jury go, oh, she just answered it. You may not even really be answering it, but that's all they'll hear. They'll know you're addressing it. So, because I did that to people when we did all their mock trial stuff back in the day, we knew they were afraid to answer the question or they wouldn't have a great answer. We would try to put some question out there that they couldn't answer. Or if they tried to do it to us, we want to make sure we said, I'll take her head on. I'm going to knock it out of the park. So just a little thing there, but it didn't sway one way or the other, the whole judging, but something I thought of.
Yeah, and that's not real nitpicky stuff. Those are stuff that I think you'll feel more comfortable doing if you take it into account. But yeah, great job, y'all. I think that's everything. Good luck going forward.
Thank you all so much.
Thank you guys so much. And great job, Carolyn.
Miranda, it was a pleasure. Good luck.
You too.
Bye, everyone.